Yes.
There's one more matter that I had mentioned. RDSO has delisted me and I can't participate in any of these ongoing tenders. There's one which is closing on 31st. If I could come any day before that, it's appearing in the month list of February. Any day before,
No, but then please mention in the next month so that I can
the tender
upgrade.
will go. I'll not be able to participate in all these ongoing. I've missed out on two.
Tenders will come and go. It's not that this will be the last tender.
No, that is true, but that's my
Then-
business. I'll take 10 minutes of your lordship's time.
10 minutes.
5.
It's very difficult to give 10 minutes time.
Any day before the 31st, if it could just be.
Well, 29th, next Wednesday. Which item?
Yes, it's appearing in the month list of February. I'll just give the particulars to your lordship.
February.
Month list of February, your lordship had made it. I sought for a correction in the cost title. Your lordship made it in the month list of February. But these tenders have now come up, which will open on 31st of January.
So an order has been passed in.
On mentioning, because the cost title had to be corrected, I had only done it. And your lordship gave me the liberty to correct it here in court. And the matter was directed to appear in the month list of February. So mentioning immediately after that, so it appears any day before the 31st.
Give the number at least.
Yes, my lord, I shall do that.
My lord, may I be?
Very grateful.
My lord, may I be permitted to mention? My lord, 276 of
No,
today's.
please do not mention anything. Don't mention.
My lord, it's extremely urgent, your lordship.
No, yes.
Order will expire day after tomorrow. My lord.
Which item?
57.
Today's list.
My lord, in that matter, my lord, the airport authority.
Who is your other side?
My lord,
I'll extend the interim order. Item number
57.
57. Where is it?
My lord, it has already been submitted. My lord, here.
It is there on record.
My lord.
All right, record and order, please. Item 57. Order niye ninto. Report filed by the Airports Authority in court today is taken on record. Item 57. The interim order that is subsisting in the matter is extended till 31st of March 2025 or until further order, whichever is earlier. List the matter on 10th of February.
My lord, your lordship, one submission. My lord, your lordship kindly remain it in the same position, my lord, because there is some urgency, my lord.
It is there in which position? Urgent motion.
Adjourned motion.
Urgent motion will be there. Tell me one thing. Did you all take a decision whether this is a final order? It's only a show cause notice.
Yes,
Then what remains in the writ petition?
kindly take it day after tomorrow, my
No,
lord.
not day after tomorrow, 10th, let it appear. 10th, 10 tarike, top of the urgent motion kore din.
Extension.
My lord, your lordship,
When
my
is it
lord.
expiring?
Extension tomorrow. Today. Yesterday it was mentioned.
Today? Is it there?
59 of for exchange of report and exception, that is complete. My lord, we got a tender. Now we need to appoint my lord subject. Your lordship please to stay when we were not there initially. Now my lord, we are going to face.
When we are not there means that means without serving.
I say that you didn't serve. Now that we are going to face trouble because we have to start the work. ESI hospitals maintenance, my lord.
Eye hospital?
ESI hospital.
Not eye hospital.
ESI.
Oh, ESI hospital.
Unless we can appoint the subtender, my lord, we cannot provide maintenance work there.
UP, yes. Yes.
So kindly take up the matter any day because even today your lordship can.
Today not possible, madam.
It's not possible.
Report and exception.
Yes.
But I appreciate his sincerity, madam. Kindly, madam.
Yes.
What tender work that would be cancelled?
He had invited this trouble for himself.
No.
No, whatever it is. Now it has to be decided.
My lord,
My lord, item number.
But this is a notice, madam, I have given.
Yes. No, he's here already. Item, which item you said?
59.
59. I'll extend it for the time being only. Extended till 28th of February. List on
10th February.
not 10th. He is in difficulty. He is in difficulty.
Only 10 days, madam.
28th of January. Next Tuesday it will appear. Next Tuesday it will appear.
My lord, item number.
Extended till 28th of February.
my lord,
My lord,
List on 28th of January under the heading adjourned motion.
my
lord, if.
lord,
At the top.
Same problem I would.
At the top.
My lord,
Non-prosecution give.
my lord,
Lord, item
may I be permitted?
6 of today's list. My lord is extremely urgent because I am I am a owner of the sandcart, your lordship. I'm mining in a sandcart. That same sandcart has been auctioned to someone else. The auction is day before yesterday, your lordship. It has not come out. The result has not come out, your lordship. But I'm in extreme difficulty, my lord. Kindly, my lord, if my lord keeps the item, your lordship, day after tomorrow, my lord. Item number
Item number
276, my lord.
of today's list.
Yes, my lord.
Who is your other side?
My lord, I have given notice to the other side, your lordship.
Who
I do
is the
have
other side?
Mr. Tanmay Chakraborty, State of West Bengal.
Serve further notice. Day after tomorrow, put it up as urgent motion. Urgent motion.
My lord, may I be permitted to mention?
You do not mention. Let the advocates be over. Then the in-person mentioning will be taken up.
My lord, may,
My lord, I beg to mention a urgent motion, my lord. Due to extreme urgency, my lord, kindly, as per official tender and work order, I have already completed the construction of a toilet in a high school, my lord.
But the payment has not
Completed,
been
but
received.
paper is not receiving
Not
money,
urgent.
my lord.
My lord, may I-
It is not urgent. Do not mention.
my lord, may I be
Yes.
permitted?
Item number 181, Lordship. I would like to withdraw, Lordship. I am the AOR, Lordship. There are certain defects which cannot be cured, Lordship.
In the writ petition.
Yes,
Which
Lordship.
item?
Yeah, Lordship, today's list 181.
181. Are you the advocate on record? Advocate on record?
Yes, Lordship.
Wait, record and order. 181 of
With
today's
authority
list.
to file afresh, Lordship.
DPO 181. Yes. Give your name.
My lord, may I be permitted to mention, my lord, if this is for upgradation, my lord, this matter.
Please don't mention. Don't mention. Yes.
Application of matter, Lordship.
No, upgradation.
The urgency that I'm mentioning is that, my lord, my account was classified as subject to fraud. A show cause notice was fixed on the 3rd of January 2025. The intimation was given for 3rd of January. However,
What
on
do
the
you want?
30
Upgradation?
yes, my lord.
Sorry,
my lord,
please
kindly
excuse.
appreciate, my lord, the
Not
RBI has
possible.
been.
I am going on updating matters.
My
The
lord,
matters are not
kindly
being
give me
taken up.
10 seconds, my lord. The 3rd of January show cause notice was fixed. 30th of December 2024, intimation given to the RBI that my account is fraud. Before I was given a chance to show cause why my account is not fraud, my lord. Now the Reserve Bank of India will take steps in accordance with law with respect to freezing my account, my lord. I am humbly beseeching my lord to kindly take the matter up on Monday, Tuesday, any day that my lord's
No,
diary
it will not be possible.
any day that my lord's
Nothing,
diary
it will
permits.
not-
Your
what
lordship,
is
may
it?
I mention this matter? Here, I am the petitioner. I deposited the amount is required
What
for
do you
that.
want?
So I am. It's for inclusion in the list, your
Sorry.
lordship.
Yes.
May I
In
not
person.
renew my prayer?
No. In person, yes.
Petitioner in person.
Yes.
একটা নার্সিং ভর্তি থাকাকালীন চিকিৎসার ডাক্তারি চিকিৎসার অবহেলা প্রতারণার কারণে আমার মা নিঃশেষ হয়, তাই এখানে আমি রিট পিটিশন ফাইল করেছিলাম। কিন্তু বর্তমানে মানে আমি অ্যাডভোকেট ঠিক সহযোগিতা করছে না বলে আমি নো অপশন নিয়েছিলাম। ওইটা যাতে আপনাদের এখানে যাতে লিস্টেড হয় টু বি অ্যাপিয়ার অ্যাজ মোশনে আছে, এটি যদি কাইন্ডলি যদি করেন যাতে সুবিচার পেয়ে যায়। এটা সিরিয়াস, ওয়ান অফ দি মোস্ট সিরিয়াস ম্যাটার আর কি। এটা যদি আপনি
সিরিয়াসনেসটা কোথায়?
ওই একজন ডাক্তার একটা নার্সিংহোমে আমার মা ভর্তি ছিলেন, তিনি চিকিৎসার অবহেলা করে প্রতারণা করে আমার মাকে নিঃশেষ একদম নষ্ট করে দেয়। সেই ব্যাপারে আমি বিভিন্ন কনসার্ন অথরিটির কাছে কমপ্লেন করা সত্ত্বেও সে ব্যাপারে আমি কোনো সুরাহা পাচ্ছি না। দীর্ঘদিন নার্সিংহোম থেকে আমাদের ভয়ও দেখাচ্ছিল, আমার ফ্যামিলি গোটা শেষ হয়ে গেছে মাই লর্ড। এই ব্যাপারটা যদি আপনি যদি লিস্টে ব্যবস্থা করেন।
লিস্টে আছে তো মামলা?
না নেই।
কবে ফাইল করেছেন?
ফাইল করেছি গত বছর 9/5/2024 করেছিলাম। তারপর
মে মাসে?
হ্যাঁ, মে মাসে, গত বছর।
মে মাস থেকে আজকে জানুয়ারি মাসে
এতদিন আমি অ্যাডভোকেট পাইনি বলে মাই লর্ড, অ্যাডভোকেট ঠিক পাইনি বলে আমি ওই জন্য মেনশন করতে পারি।
আপনার যদি উকিল বাবু দরকার লাগে আপনি লিগ্যাল এডে যোগাযোগ করুন।
লিগ্যাল এডে গিয়েছিল, ওখান থেকে একজন লয়ার দিয়েছিল, কিন্তু তিনি মানে ডকুমেন্ট কাগজপত্র ফেলে রেখেছিলেন, কিছু দেখেননি।
তাহলে আপনি একটু লিগ্যাল এডের সাথে যোগাযোগ করুন, ওরা অন্য উকিল দেবে।
আপনি যদি পারমিশন দেন আমি নিজে করতে চাই কেসটা।
নিজে মামলা করবেন, করুন।
হ্যাঁ, সেটা একটা লিস্টে যদি দেন খুব ভালো হয়। যে
লিস্টে আসবে, সময় অনুযায়ী আসবে, এরকম চলে এলে হবে না। যাবে না।
So under complex circumstances mention one matter, Lordship, the petition, there is a shop, liquor shop within the 1
What do you
kilometer of
want?
ready. Lordship, I'm paying for upgradation. Lordship.
Sorry, yes,
Lordship, I am.
Your lordship, this is a matter actually it's heard by you, your lordship, and in the November list, it you mentioned that will appear. But the thing is that there is an order from 3/10/2024, but it is not in list, your lordship. Kindly,
it's not in the list.
Madam, your lordship, may I leave to mention one matter, your lordship?
Lordship,
Mentioning in person today.
Item number 123.
Lordship,
Excuse me.
days, please, my lord.
Don't mention.
Your Lordship,
I am paying
Madam,
for
I'm
interest
mentioning in person today because my
Lordship.
advocate had told that he has mentioned in urgent motion daily list. But when I came and found out from your officers, they told me that he has not mentioned in urgent motion daily list. And the corruption of illegal stealing is going on, being enhanced by the corrupted Shastra Bhavan Nigam, DHS, DD admin, and all of them.
If you have any difficulty with your learned advocate, please figure it out with him.
Madam, I'm
You have-
requesting you to
You
take
have
the
a learned
mentioning in
advocate.
daily
I am not going to accept your mentioning individually. You
Okay.
have a learned advocate. Engage him.
Well,
Speak
But
to him.
he has, may I leave to mention?
Of 2 days.
My lord, may I have my lord's leave?
Nothing now.
Mention.
Lordship, I am paying for interest on this matter, Lordship.
Yes.
Lordship,
To file, my lord. And I'm seeking a leave to file his writ petition. my lord.
OD1, yes. Who's for the
For the
petitioner?
petitioner, my lord, on the last occasion when this matter came up before your lordship, my lord, this is regards to the handing over of the deed by the additional registrar of assurance 2. My lord would remember while my lord dictated the order, my lord, I requested for production of the original deed. Your lordship directed Miss Chatterjee to hand over a copy of that deed along with the affidavit in opposition. Now, my lord, when the opposition was handed over to me, no copy of that deed is there. Now, my lord, there are certain averments in the opposition which I need to deal with, and I cannot deal with without going through the copy of the deed because the original is
Why?
not with them.
You must be having a copy with
I
yourself.
can't because, my lord, that the original was submitted. Now, when the original is submitted, I cannot take out a photocopy of that.
Prior to submission of
My lord,
originals, you
that's-
certainly have a copy.
Yes, my lord, but the signature of the registrar at the backside will not be there.
So
And
what?
that is the point, my lord. If the registrar has put the signature at the backside of the deed, that means both the parties were present at the time of presentation as per section 32.
They want the records to be produced basically because of affidavit.
there
They
was a
must be having a
specific
copy. They
direction.
want our copy with back to
Kindly
back
sees
Xerox.
the opposition. I have annexed the
This
opposition.
is an application. You filed an application.
I filed an
What?
application. Filed an application, my lord, for a direction upon the respondents to provide me a copy of the deed which is lying with them.
Back to back Xerox
Back
of
to
the
back
deed. That is
Xerox
what
of the
they want. So they want production of the records basically. My lord. If your lordship direct, you can.
My lord,
So you have.
Lord,
You
the
must be
record
having.
must be having.
Right.
Our ground is this, my lord, that the deed was executed by the executant, but the deed was presented. He was not present at the time of presentation of the deed.
All
He
right.
was not appearing within a period of 4 months or the extended period of 4 months. So that is why it was kept pending because he has not appeared. This is our defense. He says that he was
It
present.
is not for the deficit court fee,
no,
stamp
no,
duty,
no,
or
no,
nothing
no,
of that
no,
sort.
no.
One of the party was not present.
It was not personally present. Others were present. Only one party was not personally present. Now they are
All
saying
right.
that it is possibly that is incorrect. They want
Nowadays, the snaps are taken
Yes,
in
yes.
the office of the registry,
We have
the registrar.
annexed my lord, the fact sheet from which it appears that the biometrics of only one person was not done. The others are complete. Only one person was not done.
My lord, there is no provision of nowadays, my lord, there is no provision that incomplete deed IGR will be issued.
No,
it was
no, no.
there
That is
previously.
not correct.
It was there previously that when we used to do it by deficit stamp fee, IGR was to be given, and thereafter we used to deposit the stamp fee and get the original. Now today in this case, IGR was issued. It is not the case that I have not deposited the entire stamp fee. Now, my lord, why I want the production of document? If that document is produced, if the registrar has already put the initial, that means both the presentant were
No, but
there.
then they are having records to say that one of the executant was not there.
Now, my lord, that is what I want to controvert after
No,
getting.
suppose,
Yes. Yes.
assuming the biometric of one of the executants could not be taken on that date. Why don't you produce him?
That
He's
was
not
never. That
available.
was never told to us.
Now
Number
it
one.
is told.
Number two. That
Now
person
it
has
is
died.
told.
That person has died.
All right.
That person has
Where
died.
is the death certificate?
But I'm not being able to contact him because he has taken the entire money from me. And kindly see,
How do you know that he has died?
only the advocate. It is the advocate's personal matter. Well, he has tried to inquire and he has come to know that he has died.
Bring the death certificate.
Very well, ma'am. I'll bring the death certificate.
In the meantime, can the
I
original
shall ask my client not to give me the original record.
a photocopy of the original, not the original?
I shall get a copy.
Please come. An application has been filed by the petitioner
The death certificate.
seeking a direction upon the additional registrar of assurances -2 to provide a photocopy of the deed of assignment. Within bracket back to back. Stop. Next, learned advocate representing the state respondents is directed to produce the photocopy of the original deed of assignment within bracket back to back before this court on 5th of February, 2 weeks.
My lord, only one thing, the matter was made returnable on 31st January.
31st of January.
Yes, my lord, because
Will
every
it be
day.
possible on the 31st?
I shall try. Kindly keep it on 31st.
Because
I shall try.
the office is here only. Then all right, 31st.
31st.
List on 31st, along with the writ petition.
I shall bring the copy.
This is my application. Sorry. Lordship, I entered agreement with a Chinese company named Sinotrax in the year 2019 and purchased 5 trucks. Now, trucks have been delivered to India from China overseas. Now, the 5 trucks were very defective. There was an agreement with
You purchased 5 and all
purchased
5 were
all 5
defective.
trucks. Yes, my lord.
All right.
Now, there's also an agreement for technical support for maintenance support. We tried to make communications. 3 failed because
No, but then why are all these things, Chinese
Yes,
things
ma'am.
coming over here? What is the issue?
Issue is, my lord, what happened suddenly, my lord, recently we got letters from IDFC Bank
Yes.
claiming that you remit the advance remittance which was due. Well, kindly, I will show one document. Kindly see page number 70.
Are the respondents
I am appearing for
represented?
Union of India, and last occasion Mala directed him to serve copy to RBI.
No, my lord, we have served
RBI?
We appear on behalf of the respondent number 3, Your Lordship.
the IDFC Bank.
The IDFC Bank. Yes, Your Lordship.
IDFC Bank.
And who issued notices?
The IDFC Bank. We made representation to the RBI stating that because they are showing that under RBI regulations, we are bound to pay while below the main claimant who was the sender of the trucks have never made any claims. My question, my lord, only to them is, my lord, if the person who is indebted, they are not claiming to me, why the IDFC Bank can force me to provide money? Rather, we have made part payments as per the agreement. We have shown to them.
You have any agreement with the IDFC Bank also?
No, my lord. Through IDFC Bank, the amounts has been transferred.
Then what is the head on which this money is being charged?
Lord,
On
for
what
the-
account?
Sorry, my lord.
On what account is the money being charged? There must be some reason. They
Yes,
cannot
yes.
ask anybody to pay money.
Yes, my lord.
What is the reason for charging this?
That's my lord we are asking. They are asking for the overdue amount, which has not paid to them.
Forget it. Yes, what is it?
Your Lordship, the case is very simple, Your Lordship.
Yes.
They have paid, they have exchanged foreign currency, right, for importing the trucks from a Chinese company, Sinotrack.
Whoever it is.
The, for that reason, they have used us as an authorized dealer, Your Lordship, AD. So we have done that. We have
Service charges. You want
No, Your Lordship. It's not the service charges. The bill of entry that the outstanding amount is on the bill of entry, Your Lordship.
All right.
The bill of entry is created on the, either by the importers or by the custom agencies on the basis of their purchase, and also the bill of landing, which includes GST charges, tariff charges, import charges, and all other charges that has been included on them. Your Lordship, I'll hand Your Lordship over this RBI guidelines. I'll provide you with a copy of this. If Your Lordship kindly comes up to the first, second, third, fourth, fifth, sixth. Your Lordship, the 7th page of that guidelines, Your Lordship, which has C8, Your Lordship, detailed operational procedure for IDPMS, Your Lordship.
Yes.
Yes, Your Lordship. Yeah. In that case, Your Lordship, just comes to the last paragraph of that page, Your Lordship, C10, follow up for import evidence. Your Lordship, in case an importer does not furnish any documentary evidence of import as required under para C7 from the date of remittance involving foreign exchange, irrespective of the value, Your Lordship, The bank should rigorously follow up for the next 3 months by using various modes of communication. It should, however, be ensured that at least one communication with the importer is issuance of registered letter, Your Lordship. Your Lordship, we are doing every work that has been under these RBI guidelines, Your Lordship, maintaining the RBI guidelines. It is beyond our time. The bill of entry that was created, that's outstanding. It's, Your Lordship, they have annexed, which is dated 2019, Your Lordship. It goes back to the 2019 date. And it is beyond our permissible limit to extend, to condone or extend that time. They have never sought for extension of their BOE for clearance or writing of the same, Your Lordship. We, as a EDI bank, we have the power to write off that dues, provided they give us proper notification and proper clarification as to what is the dispute, what has happened, so we can clear it off. Your Lordship, this case happened is we are not in debt of the money. They have done some import. On the basis of that, on BOE, Your Lordship, there's an AD category, there's a category that's open and telling us, compelling us that it's opened in your name. The AD code, which has been put over there, it's for us. In our records, it's showing that that has not been complied with. Your Lordship, the upcoming month, we have to file our all the taxes and all the returns. So it is beyond our permissible limits to condone that. And all the letters that has been referred to by the by your petitioner, Your Lordship, they just clearly state that we have only sought for instructions from them, Your Lordship.
Where is your letter?
Your Lordship.
Page number 83.
83. First 70, Your Lordship.
Well, you can find also in 70.
Page number 70. Your Lordship, if it comes to the letter dated 31/5/2023 in page number 70 of the writ petition, Your Lordship.
Yes.
As per the extent RBI regulations, remittances against import should be completed not later than 6 months from the date of shipment. Your Lordship, it's not in our hand to open that BOE. It's on the basis of the the importer as well as the customs.
Very well. I see in the writ petition, the petitioner has prayed for consideration of his representation. You answer what the petitioner wants to know.
Your Lordship, we have, I would hand over, Your Lordship, their letter. Your Lordship, I would hand you over the letter that they have issued. Where's the letter of Sierra Influence?
It is annexed to the writ petition.
No, Your Lordship.
89, the last page, last one.
No, not this. Your Lordship, I'll
made it to the RBI.
Yeah. Yes, Your Lordship, they have made a letter to the RBI, dated such and such, Your Lordship. I'll just surprise the court on the basis of this.
Was any letter issued to you?
Yes, Your Lordship. Page 88, Your Lordship.
18th November 2024.
They have intimated this to us. Subsequently, Your Lordship, we have sent them an email that stated that we need 4 category of documents. We have mentioned them that we need.
And you disclosed your stand.
That we are in receipt of this. If you provide us probable justification with regards to our requirements, then we can try to take steps in accordance with the law or in accordance with the guideline that has been given by the RBI.
Yes.
More importantly, Your Lordship, as per the master circular that had been handed over to you, Your Lordship, there clearly it is written that it is beyond the AD Bank's permissible limit.
No, I understand. So have you replied to this letter dated page 88?
What they are referring, we have also replied. I think they have sent on 3rd January 20.
Then what remains in the writ petition?
No, after filing the writ petition, they have sent this, Milord.
Then nothing remains?
Only difficulty, Milord. They are pressurizing me to clear the outstanding dues.
Your Lordship,
no,
this is
cannot.
Your Lordship, of
what authority they can ask me to clear the dues while.
So as per the master circular, they are doing it.
When the main company is not asking for the money.
So what? Main company is asking or not? There is certain regulations. The RBI guidelines are there.
Absolutely. I bow down to Your Lordship observation.
May I come back with the circular once?
No. The petitioner is aggrieved by the act on the part of HDFC Bank.
IDFC Bank, Your Lordship.
Oh, IDFC Bank.
IDFC First Bank, Your Lordship.
IDFC First Bank. In taking follow-up steps for regularization / settlement of bill of entry within bracket import remittance not made. Stop. According to the petitioner, the action of the bank is contrary to the provisions of law. Paragraph Learned counsel representing IDFC First Bank relies upon the master directions issued by the Reserve Bank of India relating to import of goods and services, updated as on 29th of August 2024. Stop paragraph. It has been submitted that steps are being taken by the bank in terms of the detailed operational procedures for IDPMS. Stop paragraph. It appears that the petitioner made representation before the bank, which was duly answered by the bank. Stop paragraph. The instant writ petition is disposed of by directing the IDFC First Bank to afford a personal hearing to the petitioner's authorized representative for resolving the issue in question in accordance with the master directions issued by the Reserve Bank of India. Stop. The issue shall positively be resolved at the earliest, but latest within a period of 4 weeks from the date of communication of this order. Writ petition disposed.
Grateful, my lord.
Much obliged, Your Lordship. Your Lordship, the Wakalatnama and the competency may be kept on record, Your Lordship.
It has to be filed in the department. Please do it. Record and order the Wakalatnama and the affidavit of competency. May be filed by the respondent number 3 in the department in the course of the day.
Much obliged, Your Lordship.
My lord, I am for the petition, my lord.
I'm appearing for the respondent from 1 to 5, my lord.
Respondent numbers?
1 to 5.
My lord, an application, my lord, was brought out, my lord.
Addition of successful bidder as
Addition of successful bidder, my lord. That application, my lord, copy has been served of that application. Here's the affidavit of service, my lord.
parties sought to be added.
They are, my lord, the successful bidders.
Who are they? Shorola Engineering Works.
Yes, yes, my lord. Kindly seize, my lord. Here's the affidavit of service. Item refused.
It's in Bhubaneswar. And
my lord, it's in Bhubaneswar, my lord. The copy has been refused, my lord. Kindly seize.
And the auction, the tender or auction, whatever it is, has been called for by which authority? The Eastern Railways.
Eastern Railway.
And the work will be executed where?
I'll just, my lord, apprise your lordship.
What is the status now? Has the work order been issued?
Yes.
My lord, after, my lord, during.
Sadla, my lord.
Yes.
My lord, kindly, my lord, seize, my lord, only, my lord. I'll just, my lord.
When?
December 11th, 2024.
11th of December. And the period for concluding the work? What is the period for concluding the work?
My lord, that is.
What is the work?
Yes, my lord. I'll just, my lord, indicate. My lord, kindly, my lord, takes up page 15 once of the petition, my lord. The work is, my lord, for augmentation of power supply, my lord, at station, adjoining area, yard, over MLT. My lord, this consists of, my lord, fitting of light in, my lord, the railway tracks. That is, my lord, my understanding. My lord, the bidding system is a single package system. Kindly, my lord, takes up, my lord, at the top, my lord, the bidding system. My lord, below the NIT header. My lord, below the NIT header, there is a bidding system. My lord, mentioned a single packet system. My lord, therefore, my lord, there would be, my lord, no two, my lord, different, my lord, for technical evaluation and financial evaluation, my lord, those would be considered, my lord, simultaneously. Now, my lord, kindly takes up page number 26 once. If my lord that copy is illegible, my lord, I have got a better copy for your ladyship, my lord.
26?
26. My lord, 25, my lord. 25.
Yes, it's pretty legible.
My lord. 25, my lord, at the top. Kindly, my lord, takes up, my lord, I am PP Electro Power. My lord, PP Electro Power, my lord, kindly sees, my lord, the total cost were, my lord, the net offer value is 20130. My lord, 2 crores, 1,30,000 odd. And my lord, kindly takes up the third one, Shorola Engineering. Shorola Engineering, my lord, is 2 crore 91 lakhs. Well, there's a difference of 91 lakhs, my lord, during, my lord, when the matter was, my lord, taken up during the, my lord, at the initial stage, my lord, it was submitted, my lord, the Shorola Engineering, my lord, has already been, my lord, given the work order. My lord, my rejection on what basis, my lord, I have, my lord, made a bid of, my lord, almost a then, my lord, there's a difference of 1 crore. Why, my lord, it has been, my lord, awarded to Shorola Engineering, my lord, there's no explanation.
And for that, you file a writ petition.
My lord, I make an application to them. That's when that has gone, my lord, nobody has answered.
Where is it?
T6 is my application, my lord.
Page.
My lord, page number, my lord, 29.
18th of December. Please come.
May I, Mondo?
Okay, do you have any explanation as to why Sarala has been...
Kindly come to page 23 of the writ petition,
All right.
My lord, this is 23, my lord. In the this is the annexure which they have to submit before the authority, my lord. In the starting only, my lord, this certificate is to be given by the attorney authorized signatory, each member of the partnership firm. My lord, the petitioner is the partnership firm, my lord, but the petitioner has only submitted undertaken by only one partner, my lord. That's why his bid was rejected, my lord.
My lord, page 24, my lord, is my undertaking, my lord. I've already, my lord, submitted that. কি দিলেন দিদি একটু দেখুন
My lord, as for the Indian Railway Standard General Condition also, my lord, para 6 B para 6.1, my lord, it has been clearly written, my lord, that in the partnership firm, my lord, they have to each partner have to give a undertaking, my lord.
And the power of attorney or the authorized signatory will not do.
That goes.
Your page 23 says certificate is to be given by the attorney or the authorized signatory or each member of partnership firm. Here, the petitioner has applied through the power of attorney or the authorized signatory. Where is the difficulty?
My lord, kindly come to para 6.1, my lord, which I have given right now.
Yes.
My lord, annexure 6.1, my lord, middle portion, annexure 5A shall also be submitted by each member of the partnership firm.
Is it mentioned in your NIT that each and every member is required to sign?
Not in the NIT, but my lord, this.
How will the petitioner, by any party who intends to bid, will get to know?
My lord, these rules are already attached with the website, my lord. It's there in the website, my lord.
What is the period of conclusion of the work? Validity period of completion is 6 months. It's 1 month is nearly over.
Well, this was, my lord, initially moved, my lord, during the vacation bench when, my lord, I come to know, my lord, that they have already, my lord.
They have already issued.
Already
So what can be done? Please come.
My lord, kindly, my lord,
The
my lord,
matter
direction
relates-
to, my lord, provide give an affidavit. Otherwise, my lord.
Not affirmed. All right. Okay.
My lord, kindly
The
consider, my
matter
lord, my right to
relates-
compensation and, my lord, the other remedies still remain, even if, my lord, the work goes.
The writ petition is in connection with the tender being number. এখান থেকে নাম্বারটা লিখে নেবেন তো page 15. tender number such and such, published by the, no, not published, floated by the Malda Division Electrical Eastern Railway. In the month of October 2024, for the electrical works to be conducted, to be done in connection with augmentation of power supply with improvement of illumination at station, adjoining area, yard, etc. over MLDT division. So, the petitioner participated in the bidding process. Stop. Allegation is that despite being the L1 bidder, the bid of the petitioner has not been accepted. Stop. An objection was raised before the authority. In December 2024, but the same has not been answered. Stop. Hence, the instant writ petition has been filed. Paragraph. None represents the at the time of consideration of the writ petition, it was brought to the notice of the court that the work order has already been issued in favor of the successful bidder. Leave was granted to the petitioner to implead the successful bidder as party respondent
My lord, no
and
leave.
serve.
My lord, no leave was sought for. My lord, an addition of party application was brought.
কি বললাম? Leave হবে না. An application was filed by the petitioner seeking addition of the successful bidder as party respondent in the instant writ petition. Stop. Paragraph. Copy of the application seeking addition of party was served upon the was sought to be served upon the successful bidder, but the postal article addressed to the proposed party came back unserved.
My lord, refused. My lord, this is
Unserved with the endorsement within quotes refused. Paragraph. Learned advocate representing the Union of India submits upon instruction that the petitioner is a partnership firm and as per the general conditions of contract, each member of the partnership firm is required to file an affidavit, which has not been done in the done by the partnership firm of the petitioner. Stop. Next. The paragraph, as it appears that the tender in question, now that the successful bidder has already started the subject work and it's nearly a month. Accordingly, the court is not inclined to exercise jurisdiction, inclined to interfere in the instant writ petition. The writ petition stands disposed of directing the respondent authority to intimate the petitioner the reason for not accepting their bid so that the petitioners can rectify their defect and can put in their bids properly in the future tenders that may be floated by the authority. Stop. The reason for not accepting the bid of the petitioner shall be intimated to the petitioner at the earliest, but positively within a period of 4 weeks from the date of communication of this order. The writ petition stands disposed of.
My lord, my lord, kindly, my lord, keeps the door, my lord, for other remedies open, my lord, for compensation and other things. My lord, if the answer is unsatisfactory, my lord.
No, let us see whether satisfactory, unsatisfactory, then future course of action. The writ and the connected application both stands disposed of.
Grateful.
My lord, I am for the petitioner.
আচ্ছা ওটার
My lord,
affidavit
this
of
matter-
service-টা রাখা হয়েছে in the writ petition রাখা হয়েছে আর ওটাতে leave দিয়ে দিন একটা leave granted to the advocate on record to affirm the affidavit of service in connection with the application and file the same by the course of the day. Yes, for
My lord, I am for the petitioner. My lord, this matter is appearing for the first time in the list and my counsel is not available. Kindly keep this matter not this week, my lord.
This is the first time. You should have been prepared.
Yes, ma'am. He's not
When?
well. My counsel is not well.
You are there. What's your name?
Anushka.
Where is your advocate on record?
Advocate record is also not available, my lord.
Not available. Did you serve? You are not aware. Actually, an accommodation has been sought for on behalf of the petitioner. Stop. List on 10th February. Service in the meantime.
Obliged, my lord.
My lord, your lordship, my lord, the petitioner want to withdraw this case as there are some defects, my lord, and liberty to file afresh, my lord.
Very well. Disposed.
Grateful, my lord.
But I am for the petition, non-prosecution. Two.
24 এক লেখা রয়েছে আইটেম নাম্বার 2 24 এক লেখা রয়েছে
3 I mean 3. I am 3. 2 is 2 not today. Yes, my lord. Oh, sorry. 3 I am for the petition.
হয়ে গেছে 3 হয়ে গেছে
Oh, my lord, I am for the petitioner.
Lordship, I am for the bank.
I am for the state, your lordship.
My lord, I am for the petitioner. I am praying for non-prosecution of this writ petition, my lord, because of followed by the provisional certificate, my lord. One-time settlement has been done and the due amount has been paid. So that's why, my lord, I am praying.
grievance redressed disposed respondents are there
Respondent number 6 and 7.
state ছাড়াও 6 আছে
Mr. Rao Srivastava is appealing for the state, your lordship.
no she is also there
Oh,
No,
she's
lordship.
for the bank, your lordship.
Bank, lordship.
হ্যাঁ তো ব্যাংকের অ্যাপিয়ারেন্সটা নিয়ে নিন
হ্যাঁ আমি দিচ্ছি।
তাই বলুন
My lord, may I submit the application issued communicated by the petitioner?
yes
Much. Lord, I am mapping for the petitioner. I am praying for short passover, my lord.
urgent motion no passover
My lord, Mr. Senner.
I am sorry otherwise
The private respondent.
otherwise the list cannot be completed What is it? State?
I am for the state.
Yes, you are for the?
Private respondent.
Which
All private
one?
respondent.
All the private respondents.
7 to 10.
How many?
7 to 10. 4 private respondent is there.
4 private respondents. Wakalatnama filed?
Yes, madam.
All right. Yes.
Epidemic service, madam.
Yes, yes. What is the matter?
The matter, my lord, I am challenging the order which was passed by District Magistrate Purva Medinipur, the jurisdiction point on the ground of jurisdiction point and maintainability point, my lord.
Which one? Where is the page?
Impugned order, my lord.
Page 127 onwards.
127 onwards. I made an application, the maintainability point before the district magistrate.
Under which provision? West Bengal Land Eviction of Unauthorized Occupants Act. Yes.
Section 7.
Jurisdiction of the order has been passed by whom?
By the district magistrate.
A district magistrate doesn't have the authority?
The collector. No.
Who is the competent authority?
Competent authority, my lord, the collector of, commissioner of the division.
No, my lord.
No, the order.
It is the collector.
No.
Collector is the DM.
My lord, when the collector has been passed an order, that should be challenged before the division, commissioner of division, my lord.
It is the pass করেছে. My lord, this original.
1 minute. Page 127, you are impugned by this order passed by the DM and collector.
My lord.
Under the provisions of the public land eviction of unauthorized occupants.
Yes, yes, yes.
You say the DM does not have the authority to pass the order?
Yes, yes.
Who is the authority?
Authority is the commissioner of division, my lord.
Show me.
Yes, my lord. I am saying, my lord.
Section 7 of the.
এই বইটা আনন তো শর্ট করে ওয়েস্ট বেঙ্গল পাবলিক ল্যান্ড এভিকশন অফ আনঅথরাইজড অকুপেন্টস অ্যাক্ট 1962
আপনার কাছে আছে
Yes, show me the book. Where is the law? You've not brought the law. You are appearing for the respondents.
I don't have.
Why? বইটা দিন বইটা দিন West Bengal Public Land Eviction of Unauthorized Occupants Act.
My lord, kindly see the section 7, my lord.
My lord, kindly see first.
Let him place his case. You are not ready with the book and now you say section 7 and section 17.
Kindly see the definition first, my lord.
Definition of?
Section 2.
Definition of what?
What? As a collector.
Collector, yes.
Kindly see.
The chief officer in charge of the revenue administration of the district includes an additional district magistrate, especially appointed by the state government. Chief officer in charge of the revenue district.
Yes.
Charge of the revenue administration of the district.
The collector, the definition of the collector, when the district magistrate, when the subdivisional magistrate pass an order, that should be challenged before the.
Where is the subdivisional magistrate's order?
My lord, this is a subdivisional magistrate order, my lord. This is a SDO pass an order.
Where is it?
Yes.
Page 27 is by the district magistrate.
Against the order of the SDO, my lord, he passed that order. That is page 123.
101, my lord. Page 101.
101.
127. 101.
101.
Third of December 2022.
13 December of 2022.
13
December.
All right, 13 December. Who passed this order? The subdivisional officer. 13 December. Plea for eviction under the such and such is dismissed. You want the private respondents to be evicted?
No, I am the private respondent who is occupied the public land, my lord.
You are occupying the who approached the SDO?
The petitioner,
Petitioner
private
approached the
respondent
SDO.
approached the SDO as per the order of the High Court, my lord.
Yes, and challenging this order,
Challenging
an appeal was preferred before the
district magistrate.
District magistrate, and district magistrate has passed order.
Yes, yes. Without a non-speaking order passed on district magistrate, that has been also challenged, my lord.
Yes, my lord, that is a non-speaking order. That is not a written order.
This is not a reason order.
Non-speaking?
Yes, my lord. Totally non-speaking order. Not only that, my lord, the section 7 also stated the after 15 days they have been preferred and filed an application or the restoration application. That has not been done also. That I have also stated, my lord. Only is the baseless application, baseless. No reason has been assigned. The SDO passed an order in favor of me, in favor of us, petitioners. The elaborate discussion is there. My lord, petitioner filed an application for their ingress and egress. The BLRO says that there is sufficient space to ingress egress of the private respondent. Therefore, the categorically stated why the application has been dismissed by the SDO. But the district magistrate passed an order without assigning any reason why they have said.
Please come. The order passed by the district magistrate Purva Mednipur on 24th December 2024 under the West Bengal Public Land bracket open eviction of unauthorized occupants bracket close Act 1962 is impugned in the instant writ petition. Stop paragraph. The petitioner submits that the district magistrate is not the competent authority to decide the issue. Stop. The issue of jurisdiction was raised before the district magistrate, but without considering the same, the impugned order has been passed. Paragraph. The learned advocate representing the district magistrate Purva Mednipur admits that the impugned order is a non-speaking one. Paragraph. On a perusal of the same, it appears that apart from observing that there are several encroachers over the government land, the district magistrate has not assigned any reason for directing the subdivisional officer to take steps for removal of the unauthorized encroachment. Stop. Especially when an issue of jurisdiction of the district magistrate has been raised, the authority ought to have adjudicated the same. Stop paragraph. In view of the above, the order impugned is set aside, being a non-speaking and a cryptic order. Stop. The competent authority is directed to decide the issue strictly in accordance with law at the earliest, but positively within a period of 8 weeks from the date of communication of this order. Stop. An opportunity of hearing shall be granted to the parties for production of all documents in support of their respective stand. Stop. Reasoned order shall be passed and communicated to the parties immediately thereafter.
My lord, may I permit? My lord, maintainability point kept open, my lord.
Which maintainability?
My lord, the DM has no authority at all.
I have recorded that. বইটা ফেরত দাও। এই বইটা আনান। Six. Service is taken on record.
I am for that. Affidavit of service. The petitioners are the owners of the subject lands.
Microphone.
The father of the petitioners, my lord, purchased the lands in question, my lord. My lord, while my lord, the backdrop is that the order was passed by the my lord West Bengal Land Reforms and Tenancy Tribunal, my lord P1, wherein the members of the tribunal, my lord, directed the concerned authority to record the name, record the lands in question in favor of the applicants, my lord, under the provisions of the 14U3 of the West Bengal Land Reforms Act, by deducting equal quantum of land from the erstwhile riot or his successors.
What is your prayer in the writ petition?
My lord, the PHC main, my lord, without giving any notice, without any authority or law, my lord, enter our land and started construction, my lord, in the month of December.
One application, page 26. Before against the allegation is against the PHC, my lord.
That can be considered.
Considered by the respondent number. The respondent number 5. PHC asking that will be considered. Page 26, my lord, that is the representation.
Respondent number 5 will consider. Very well, please come. The petitioner alleges that the Public Health Engineering Directorate is illegally encroaching upon the Rahati agricultural land of the petitioners and trying to raise construction of water tank. Stop. An objection was filed before the respondent authorities in December 2024, but the same is alleged to be kept pending. Paragraph. Without entering into the merit of the allegation of the petitioners, as it appears that the representation filed on behalf of the filed by the petitioners are pending consideration at the end of the Assistant Engineer Tomluk Subdivision PH Directorate. Accordingly, the instant writ petition is disposed of by directing the respondent number 5 to consider the objection filed by the petitioners strictly in accordance with law at the earliest, but positively within a period of 8 weeks from the date of communication of this order. Stop. A site inspection shall be conducted to ascertain as to whether any construction is being made over the land
they are
claimed by
making
the
construction, my
petitioners.
lord. The assistant engineer making construction, and it should be completed very soon, my lord. Unless the consideration of the representation, there may be a status quo.
Attempt to encroach the
Assistant engineer is making construction.
My lord, kindly, my lord, thereafter they kindly see those photographs, my lord. They are constructing.
As the allegation is that the assistant engineer is raising construction, can the direction be given upon the BDO to see?
No, my lord, the DM, my lord, DM.
Then
DM, my lord.
Yes, then some senior officer must see apart from the assistant engineer because the allegation is against the assistant engineer.
My lord, the district magistrate,
the-
my lord. Respondent number 2.
Then my lord, SDO will conduct with the help of the the assistance of the assistant engineer. Assistant engineer must be there. SDO, subdivisional officer.
SDO
Yes, my lord. That is
or the district magistrate
district magistrate, my lord. There are
through the
yes, my lord.
competent authority.
Yes, my lord.
আচ্ছা রেসপন্ড নাম্বার 5 কে বলবেন না দি ডিস্ট্রিক্ট ম্যাজিস্ট্রেট পূর্ব মেদিনীপুর যেখানে রেসপন্ড নাম্বার 5 বললাম সেই জায়গাতে ডিস্ট্রিক্ট ম্যাজিস্ট্রেট পূর্ব মেদিনীপুর আচ্ছা spot inspection shall be a spot inspection shall be না লিখুন the district magistrate shall cause a spot inspection
With the help of the respondent number 7, my lord.
with the
Block land and land defense officer is
with the aid and assistance of the BL and LRO
yes, my lord. Respondent number 7.
Nondigram 3 to ascertain as to whether the allegation of the petitioners is proper or not. Stop. If it appears that the allegation of the petitioner is correct, comma, then necessary remedial steps shall be taken. Paragraph. Learned advocate for the petitioner is directed to forward a copy of the representation along with all supporting documents to the district magistrate and the block land and land reforms officer Nondigram 3 for taking steps in compliance of the direction passed herein above. Disposed. হ্যাঁ ঠিক আছে আমি জানি
7, my lord, I am appealing for the petition.
Lordship, I beg to intervene on behalf of the respondent number 3. I am the principal respondent. Grievance is against me. No copy has been served upon me. And Lordship, yesterday when the leave was obtained from your Lordship, it was submitted that the petitioner has an existing lease which is continuing till 2026. In spite of that, my client has issued tender. Considering such submission, your Lordship has permitted the petitioner to move this petition today. And it was undertaken by the petitioner that the copy will be served, but copy has not been served.
All right, give a copy. Where is it?
My lord, that is
Kindly ask him to show the
speed post I served. My lord, that is
A speed post, if yesterday you have served, today they will not receive.
my learned friend I served because my lord, I did not know who is appearing for another.
Yes,
respondent
so
They were the
My
address they
lord,
could have served. They have urgency. They could have personally
my
served
lord,
copy of the petition.
I am
very
serving
well.
a copy of
Well, can it be taken up on Friday so that he can come ready with instructions?
My lord, 24th is the date of auction. My lord, from 10 to 5. If your lordship kindly take up matter in the morning, my lord, as a first item,
No,
then
matter will not be taken up at 10:30. It will be taken up only after the original site list is over. Take instructions in the meantime.
So I have obtained instruction. I can do the matter right
Then,
here.
then it's all right. Then let us proceed.
First of all, let him establish his existing right over the
Let her place her case.
I am challenging
and
the
on the self-serve cause
1
of
minute,
action.
let her
one
place her
petition is
case.
pending.
I am challenging the auction notice that is published in the website. That is page 69.
69, yes.
69 onwards and page 69, Manol, if your lordship kindly see the data which has been published in the website, that is bid data sheet. And if your lordship kindly see the mode of submission of bid online and top details of the sand block. My lord, only block has been given, no category has been given, no specific region, no specific block, no specific
No
sector.
block ID has
My lord,
been.
only block River Damodar, entire River Damodar, if your lordship kindly see for a moment the auction rules, that is, my lord, my specific case is violation of the auction rules 5.2 and 9.1. That you will get your lordship.
Did you raise this objection before the authority?
Yes,
Page.
I raise objection, that is page 23. On 5th January 2025, my lord, I raised objection before the authority concerned.
Page 23 on 5th
Page
of January.
23.
2nd of January. When was this auction notice published?
My lord, that is 2012. That was uploaded later. My lord, previously.
All right.
20th December it was uploaded.
1 minute. Tell me, where is your existing lease or license, whatever you have?
That is, I am not existing leaseholder, and that was not mentioned before your lordship, as well as I not mentioned in my writ application also. My lord, I am challenging that is whole entire river of Damodar has been auction in the by way of auction. They, my lord, publish the bid. I am not existing leaseholder at all, and my lord, in writ application that was not submitted by me, that I am a leaseholder.
But then yesterday you mentioned.
Yes, Lordship, at the time of leave, I was there. Yesterday when the
you
leave was
mentioned
obtained,
that you
it
are
was submitted that he's an existing lease.
My lord, only I am challenging the auction process. Auction process that was the uploaded in
the block ID is there. Do you intend to participate or not?
My lord, I intend to participate.
What remains?
My lord, that is auction will be held on 24th.
Go and participate. Who's stopping you?
My lord, now today they already closed the uploading the.
Why did you not take steps in due time?
My lord, I raised objection.
No, raising objection will not do.
And if your lordship kindly see the page 30 and 32 for a moment.
Sorry, if you intend to participate, you should
have.
have.
Your lordship kindly grant me my liberty, because that
Why?
was closed. Closed already.
No, Lordship,
closed.
24th is the last date.
24th?
Yes, Lordship,
Show
kindly
me.
come to the from the.
That is
No, last date for submission of the documents is 16th of January.
No, Lordship, date of publication is.
Publication is after the all bids are over.
Sorry.
So
24th
last date is over.
Auction.
If you fail to participate, nothing doing.
Kindly give me liberty.
Not at all.
Because
Now, Lordship,
kindly see for a moment. Page
Lordship, kindly hear me.
I cannot.
Page 30
Lordship,
and 30.
it is not for the entire Damodar. Lordship, kindly come to page 71. The geo coordinates are there. And Lordship, this is not a public interest litigation
Yes,
that everybody can challenge the tender process. Kindly come to page 71.
71.
That is the geo coordinates. This particular block was put into auction.
Very well. Please come. The
And
petitioner
absolutely,
has filed
on the same cause of action, another writ petition is pending.
That was at that time not uploaded. At that time, is my objection. And
the petitioner challenges the auction notice published by the West Bengal Mineral Development and Trading Corporation Limited for selection of mine developer and operator within bracket caps MDO of sand blocks in West Bengal. Stop. It is the specific submission of the petitioner that the detail of the sand block is not mentioned properly in the auction notice. Stop. According to the petitioner, the entire river Damodar has been mentioned as the sand block for auction, which is not true. Paragraph. An objection was filed by the petitioner on 2nd January 2024, and the same is alleged to be kept pending. Paragraph 24. 25, 2nd January 25. Achha. From the bid data sheet and the bid schedule annexed to the writ petition, it appears that the last date / time for submission of documents in connection with the bid is over. Stop. The tender document was published in the website on 20th December 2024. Stop. The auction is due to be conducted day after tomorrow at 10 o'clock. Stop. Paragraph. The petitioner has not submitted his bid. Paragraph. Learned advocate representing the
respondent number 3.
Respondent number 3 denies the allegation of the petitioner. It has been submitted that the
at page 71, the
geo reference
Geo-coordinates.
Coordinate of the sand block which has been put up in auction is already annexed to the writ petition at page 71. Stop. The latitude and the longitude of the area put in auction is mentioned therein. Stop. Paragraph. On a perusal of the documents annexed to the writ petition, and upon hearing the submission made on behalf of both the parties, it appears that the grievance of the petitioner is unsubstantiated. Stop. The detail of the sand block which has been put up in auction, including its latitude and longitude, has been published by the tender inviting authority. Stop. Paragraph. In view of the above, no relief can be granted to the petitioner in the instant case. The writ petition fails and is hereby dismissed. Service is taken on record.
A copy may be given for my regular
Professional reasons. Take a copy. Make a photocopy.
Post করেছি কি?
Next.
My representation should be considered.
That will be considered.
Within a certain time.
But this type of practice should be stopped. When somebody is, your lordship, upon relying upon the submission of the learned advocate,
absolutely,
lordship, this should be stopped. Because I
Yes,
was present
8.
yesterday when the leave was obtained.
8.
I am for the petition.
I am for the state.
I am for the private response.
My lord, I am appearing in such a case where I am to be killed. Now I am to be
dead already.
Yes, I am to be killed. Now I am choosing, my lord, who will kill me. Now they have proceeded in a manner that these lands.
Who is Lokhikanto Maiti?
Private respondent is here.
All right.
On
And state.
on the claim of this private respondent, my lord, a proceeding was initiated.
Under section.
Under section, my lord, under Highways Act, National State Highways
Highways.
Act. And ultimately, the SDO came to a conclusion that yes, I am an encroacher upon the, my lord, land which belongs to state highways. Order for removal of encroachment that was passed. But we went to the appeal. The appellate authority, that's the DM, he came to a finding, yes, we are the encroacher, we have to move. Why I am before your lordship? Our case is that it's not a land belongs to state highway. It's a land belong to national highway. And national highway number 17 as well as 117.
Did you make the national highway a party?
Yes, my lord. Yes, my lord.
Where?
The executive officer, respondent number 4, if I'm not wrong.
Executive Officer, National Highway.
Yes, my lord.
Did you serve? National Highways Authority.
Yes, my lord, they have
National
served,
Highway is
sir.
not the proper expression.
Yes, supplementary.
Oh, what is the state stand? Is it the state highway or the national highway?
Our stand is, my lord, they never raised that point. But we have our, according to the order of the game and SDO, my lord, that is the state highway.
Oh, what does your record say? Is it state?
But may I indicate that particular portion in the order? Acha, acha.
My lord, in this matter, we never raised that point, and my lord, everything, my lord, SDO and that game, this, my lord, order is perfectly right, my lord. According to the.
No, tell me one thing. Suppose this issue has not been raised by the petitioner, but you cannot go and direct the petitioner to be evicted from somebody else's land. Had it been your land, it is all right.
That point must be raised before the authority.
Suppose it is not raised.
Then, my lord, according to us, my lord, that is a state highways act.
Look, there is a categorical finding.
Show me that it is the state land.
And Milord, subject
kindly
to
come
correction by
to-
Mr. Jahan, I am not disturbing. Mr. Jahan, Milord, there are numerous, Milord, illegal encroachers. As per the writ petition contention, only 4% are in front of national highway. Only 4. Milord,
I have some other
16,
submission. Let me
1,
complete
3,
me.
8,
Let me complete me.
All right,
Kindly
please.
come to page 79. The order of the
79.
district magistrate.
Yes.
Now, one of the fourth paragraph from top. It's order dated 26th of December 2024.
Yes.
The representative of the assistant engineer PWD Road, Joynagar subdivision submitted that although RS plot number so and so under Moja, Akhoynagar district South 24 Pargana is recorded in the name of the collector of government of West Bengal in ROR. It's a public land. But the land
adjoining the road is being maintained by the PWD Road Directorate for a long time. So land is being maintained by the PWD. He submitted that the appellate authority should treat the said land as PWD land because the land is covered under section 2C subsection II of the West Bengal Highways Act 1964, which states that the highways includes any land in the possession of the state government or any other authority adjoining such highway. Which highway?
State highway.
Which highway? Where the highway is, where the state highway is. They never said this is these state highways. Rather, my claim is that, my lord, from Bokhali to Assam, somewhere, my lord, NH 13, NH 17, NH 117, NH 34, NH 31, and presently that's being recognized as NH 12. This is going on. So this is the property of NH, national highway, not of state highway. My lord, if
when is the date of your removal?
But today they are already present there. I mentioned this matter yesterday before Lordship, because my lord, they have served. They sent me a letter dated 17th of January asking me to remove it by 21st. If I fail from 10 a.m. or 22nd, they will. This I shown before Lordship. My lord, kindly, I am supplying this as a supplementary affidavit. My lord, same thing. But may I pray for one thing, my lord? Let there be a stay of limited time. Let them make a joint inquiry in presence of National Highway Authority, State Authority, as well as the private individuals surveyor. But if it is found that my claim is wrong, but I should be imposed with high, extreme punishment or whatever may be, your lordship.
Listen, the portion that you read out, it mentions about the RS plot number, which is recorded in the name of the collector.
Yes.
So it is the state
Collector
land.
means state land.
Right.
No, 1962 Act.
It is the state land. But the land adjoining the road is maintained by the PWD roads, and then the Highways Act definition has been taken. So it implies that it is the state
Unless declared as state highway, it cannot be under State Highways Act.
But then the West Bengal Highways Act 2C show me this provision. It is mentioned.
It says adjoining to the state highway.
Right.
Now a highway is to be there.
No, any land
yes,
in
my
the
lord.
possession of the state government or any other authority adjoining such highway.
Such highway.
Such highway means the
Such highway means the state highway. State highway needs to be declared as state highway, my lord, under that particular provisions of law.
Yes.
All PWD road is not the highway.
But it is a PWD land.
If it's a PWD land, my lord, if not covered under the state highways, then they have to take initiatives under 1962 Act. And one thing more, what came here, my lord, a portion of land from the private person that was acquired by the government.
Yes.
Some of, except 1, 3, 8, and 15 petitioner's number. Rest are the encroachers of the private land, the land of the private respondent here.
Not the government land.
Not the government land.
All right.
A portion of his land that was acquired by the government. They are being shown that no, you are not in the position of him, but the position which was taken out by the state government.
Yes, the portion which has been acquired is a marked portion.
Now, the position acquired and position he has, if it's, my lord, added, the land would be, my lord, extra. That cannot be. But let us come back with a full-fledged inspection. But I am to go, my lord. But let me die with a proper authority.
Is anybody there for the National Highway Authority?
Lord, may I just assist your lordship, Lord? Now, Mr. Jahan has said.
Even yesterday, my lord, we have.
Very well, my lord. May I assist your lordship, my lord? Mr. Jahan, my lord, subject to, my lord, full of respect, my lord. Whatever the submission from the bar is being made, my lord, it's beyond the record. It's a 2014 proceeding once initiated by my client in the year 2014. The writ petition was being disposed of by this Honorable Court Coordinate Bench, wherein, my lord, 3 reports were being submitted. By joint inspection report by the concerned BLRO. If your lordship takes up that order, that will clinch the issue. And it takes up page 28 once. This order is being challenged by them. They couldn't able to succeed that. The contempt proceeding is pending. My lord, if your lordship takes up page 28, the order starts.
And the appeal is also pending. I believe so.
I will submit everything. Lord, page
28.
If your lordship straight away comes to page 31.
Yes.
Upon Milord, the first paragraph, Milord, I'm skipping. Milord, upon perusal of the final demarcation report, has your lordship got it? Milord, they are the private respondent in that writ petition. No challenge to the inspection report, nothing. Milord, I shall show before your lordship. Upon perusal of the final demarcation report dated such and such submitted by the Block Land and Land Reforms Officer Kagdip, South 24 Parganas, it is found that there has been encroachment of 38 numbers of encroachers on the PWD land adjacent to the land of the petitioner. The petitioner land is butted and bounded on the western side by Namkhana Kagdip Road, on the southern side of the Gangadharpur bus route, and on the eastern side by a Pakka road. By its report dated such and such, the executive engineer, Diamond Harbour Highways Division, Public Works Department Directorate, has indicated that the land on the southern side of the petitioner's land falls within its jurisdiction. The land encroached by the encroachers under serial number 11 to 35 is situated adjacent to the Gangadharpur bus route on the southern side of the petitioner's land. Accordingly, the executive engineer, Diamond Harbour Highways Division, Public Works Directorate, respondent number 3 is directed to take appropriate steps for initiation of proceeding under 1964. 1964 for removal of encroachment under serial number 11 to 35 as per the sketch map indicated. I shall show the sketch map also that is submitted to them. Indicated to the report of the Block Land and Land Reforms Officer Kagdip, South 24 Parganas, dated such and such, within 2 weeks from conclusion of the general election such and such. After giving notice to all concerned, including the petitioner as well as the private respondent, such proceedings should be taken to its logical end. Now, Milord, I am coming to the second phase where my learned friend is asking about 1962 Act to be invoked. It is informed by the learned advocate representing the state respondent that land encroached by the private encroachers of serial number 1 to 10-1 and 36 to 38 on the western and eastern side of the petitioner's land falls within the jurisdiction of the collector. Accordingly, the collector, 24 Parganas South, or any authority empowered under the Act of 1962 is directed to take appropriate steps for initiation of proceeding against the encroachers under serial number such and such within a period of 2 weeks from conclusion of the general election. So, my lord, your lordship has already got that, yes, a full-fledged inspection was being carried out, report submitted in their presence. It has been found that they are the illegal encroachers, wherein the 1964 Act is to be invoked and wherein the 1962 Act to be invoked. Two parallel proceedings. My learned friend, now his grievance is in respect of 64 Act. Even, my lord, after conclusion of this proceeding, there was further inspection done. My learned friend has annexed that copy also. If your lordship takes up page 72. Today, from the bar, Mr. Jahan will say that, yes, it is not in the state highway, it is on the national highway. Without annexing any scrap of paper to that effect, he cannot say that entire proceeding should be stalled for that. 72. Page 72, if your lordship once takes up, this inspection was being done, my lord, even after the order of the coordinate bench of your lordship's court. In reference to the above mentioned subject, a demarcation was held on 23rd of December 2024 regarding the order of Honorable Justice such and such in connection with WPS such as the matter of Lokhikanto Maiti versus such and such. In presence of personnel of the Public Works Department of the Government of West Bengal and all persons against whom notice was issued, field inquiry was conducted on the basis of RSLR map and the acquisition map of PWD. That reference your lordship will find DM in district magistrate's order. Following points were revealed from the field verification. All people of serial number 1 to 16 mentioned in the annex sketch map are occupying RS plot number 525-813 corresponding to LR plot number such and such. From present computerized land record, it appears that the plot measuring such and such acres classified as Noyenjuli is recorded in the name of Collector, Government of West Bengal. Next, the serial number 17 to 38 mentioned the annex sketch map are occupying RS plot number such and such corresponding to LR such and such. At the present computerized land record, it appears that the total area of such and such acre, though only 0.119 acre of this plot is recorded in the name of Lokhikanto Maiti. From the acquisition map, the provided that the personnel of PWD is reveals that these people serial number such and such are residing over the acquired area of PWD of the Government of West Bengal. So it's a fact-finding authority, my lord. After scrutinizing of all materials of record, they have arrived this. Now kindly takes up, my lord, the order passed by the Milord authority, the DMs, Milord, page 79. This has been, Milord, gone into by the Milord district magistrate. Milord, if your lordship takes up, my lord, the fourth paragraph of that, my lord, page 79. The representative, has your lordship got it? The representative of the assistant engineer PWD road, Joynagar subdivision submitted that although RS plot number such and such, Mouja such and such is recorded in the name of collector in ROR, but the land adjoining to the road is being maintained by the PWD. It's a specific finding. Section 213, my lord, gives that definition that if it is adjoining to the state, my lord, the highways, then the PWD is the authority over which, my lord, no encroachment can be, my lord, there. My lord, kindly turns over the page, and my lord, the last, my lord, paragraph may I submit. Considering the submission made by all the parties and the case record being the district magistrate and such, I am of the opinion that the present appellant have made unauthorized structure on the public works department land and some parts of the collector's land, which is being maintained by the PWD directorate, which is illegal and that is liable to be removed. Therefore, the prayer of the appellants is hereby considered and disallowed. The order dated such and such, passed by such and such, is affirmed. Now, my lord, a fact-finding authority, after scrutinizing of the record with the expert body of the land, my lord, that BLLRO, my lord, have found that this has been done. And this exercise, if your lordship once looks up, my lord, this is the plan and the report which has been submitted before the learned single judge on the last.
That I have annexed. Perhaps that has been annexed.
My lord, there specific delineation, everything was being done. Today, my lord, my learned friend wants to re-agitate the issue which ought to have been raised, my lord, in respect of that order. My lord, I must submit before your lordship, challenging the order of your lordship's coordinate bench, and appeal has been preferred. My lord, the appeal times and again came up. It was a defective appeal. Section 5 initially not filed. Direction was there to cure the defect. Since the contempt application was pending, they've taken the point that the appeal is pending against your lordship's order. But his lordship directed this compliance. Today itself, the appeal was being listed before the Honorable Division Bench. They have not served the copy of the Section 5 application. They not even served the copy of the supplementary affidavit. The Honorable Division Bench was annoyed when I, my lord, submitted that this action have been, my lord, done and a fresh writ petition is being filed. Their lordship was pleased to adjourn, my lord, the matter, my lord, for 3 weeks. My lord, there the different learned advocate appear. My lord, from 2014, this was going on. Initially, once an order has been passed, contempt application.
Where will I have followed?
Or kindly takes
Yes.
of State Highways Act, Section 10 once.
No, but then
Only 2 sentences, I will read out from there, my lord.
yes.
The Section 10, subsection 1, if any person is found to have made an encroachment on any road, street, pathway or land which is declared to be a highway under subsection 3 of Section 3. This is the first condition. Now, Section 3, subsection 1 says, but the state government may by notification in the official gazette declare any road, street, pathway or land to be a highway. Now, 2CIA, which they have relied, my lord, that should be adjoining or adjacent to such an highway.
Please come.
Now, there is no highway at all. And my specific grievance,
petitioner
that's
is
it's a
aggrieved
part of
by the-
117. In his 117.
By the implementation of the direction passed by the district magistrate, South 24 Parganas, dated 26th of December 2024, whereby the district magistrate came to a specific finding that the illegal encroachment over the government land is to be removed. Stop paragraph. The respondent authorities are taking steps for removal of the unauthorized encroachers. Stop paragraph. The learned counsel representing the petitioners submits that the land from where the petitioners are sought to be evicted does not fall within the definition of state highway.
Only, my lord, petitioner number 1, 3, 8 and 15. Kindly see paragraph 15.
1, 3, 18, 15 for
Paragraph
national highway. And in all cases, my lord, state highway is not applicable.
Next.
Paragraph
National highway জন্য বলছি, বাকিদের জন্য অন্য কথা আছে তাতে।
কি বললাম? Does not fall within the definition of highway. Stop. Without without ascertaining the fact whether the highway belongs to the state or the national highways authority, comma, the district magistrate has passed order for district magistrate has illegally and arbitrarily passed order for removal of the encroachers. Paragraph, prayer has been made to stay the eviction proceeding for the time being and direct the highways authority, both the state and the national, to conduct joint inspection in the presence of the private parties. Paragraph, learned counsel representing the private respondent refers to the order passed by a coordinate bench of this court on 29th of April 2024 in WPA 24678 of 2014, page 28, with Likenevan. Within brackets, Sri Lokhikanto Maiti versus State of West Bengal and others, wherein the court took note of the final demarcation report submitted by the Blockland and Land Reforms Officer, Kagdeep, South 24 Parganas. Stop. The stand of the executive engineer, Diamond Harbour Highway Division, Public Works, within bracket Roads Directorate, was also considered. Stop. The court specifically directed the collector South 24 Parganas or the authority empowered under the Act of 1962 to take steps for initiation of proceeding against the encroachers within a stipulated time period. Stop. Paragraph. The challenging the order passed by the Honorable Single Judge, an appeal has been preferred by the writ petitioners herein, but no order has yet been passed, staying the operation of the order passed by the learned single judge. Stop. Paragraph. The petitioners try to create a confusion over the action taken by the district magistrate under the provisions of the West Bengal Highways Act
1964.
1964. Stop. Paragraph. It has been submitted that steps ought to have been taken under the provisions of the West Bengal what is the 62 Act? West Bengal Public Land, bracket open, removal of unauthorized occupants, bracket close, 1962. Removal, eviction of unauthorized occupants, 1962. Stop. Paragraph. It appears that the aforesaid submission was also made before the coordinate bench and the court considered the same and passed necessary order. Stop. Paragraph.
The coordinate bench directed that the appropriate step is to be taken. Page 33.
No, prior to that, my lord, page 31.
In response to the order,
No, 1964 also said.
compliance
1962,
with the order passed by the learned single judge, the Blockland and Land Reforms Officer, Kagdeep, South 24 Parganas, conducted further spot inspection to demarcate the portions which were encroached by the encroachers. Stop. A report dated 24th December 2024 by the Blockland and Land Reforms Officer is on record. Stop. It appears that the RS plot number 525/813 corresponding to LR plot number 674 of Mouja Akhoynagar, jail number 38, page 72. Is classified as Noyon Julie and recorded in the name of the collector. The impugned order dated 26th December 2024 also takes note of the aforesaid plot numbers. That is RS plot number 521/685 and RS plot number 525/813. Stop. There is a specific finding that the aforesaid plots of land belongs to the state. Stop. The contention of the petitioners that it is not decided whether the said lands belong to the state or the central cannot be accepted. Stop. Next. In view of the above, the court is convinced that
And one
there is hardly any error in the order passed by the District Magistrate South 24 Parganas, which has been passed in conformity with the direction passed by the Honorable Court. Stop. The unauthorized occupants are encroachers are liable to be evicted. Stop. The court is not inclined to exercise jurisdiction in the instant matter. The writ petition fails and is hereby dismissed.
Great. They didn't disclose which state highway. They didn't, Madam.
Great.
Yes, 9. এগুলো ফেরত দিয়ে দিন।
Supplementary affidavit.
Supplementary affidavit is taken on record. Supplementary টা রাখবেন, supplementary আছে দেখুন নিচে, ওটাকে রাখুন, ছবি আর ওইটা ফেরত দিয়ে দিন। 9.
I was thinking whether I was thinking whether everybody is served or not, because affidavit service does not depict so. All are appearing, I'm saved.
Yes.
There is a land was allotted to us. It is a condition that within a specific time I have to construct and do whatever in the stipulation there. There is a clause that if I don't do, counter resumption, like all other deeds in the government. There is an order of resumption. I challenge before a Lordship's court. I will start from that order. But kindly come to Order of Justice Ghosh at page 28.
Yes.
But I will request your Lordship, my Lord, to read if possible, or I will place it, my Lord,
only the relevant portions, please.
Then, my Lord, kindly come to 31.
31, yes.
Since the petitioner seeks to submit a representation before the concerned authority for consideration of the same by the latter, the writ petitioner is disposed of with liberty to the petitioner to submit a comprehensive representation before third respondent within 2 weeks from date. The third respondent is directed to consider and dispose of the representation within 2 weeks from the date of receipt thereof, affording reasonable opportunity of hearing to all the interested persons, including the petitioner, in accordance with law. Pending this for representation, the notice of resumption dated such and such is stayed. So there is a notice of resumption of 2022. My Lord, in terms of this order, I was called. My Lord, I file a representation. My Lord, kindly come to 130.
Yes.
I was given a hearing on the basis of my representation.
Yes.
Here also, my Lord, I will not trouble your Lordship the entirety. Kindly come to the next page. The last but one paragraph. And whereas, after considering the hardship faced by the concerned writ petitioner, like effect of demonetization resulting in financial crunch, along with pandemic occurred throughout the country on account of unprecedented COVID-19 coronavirus, as being mentioned in the writ petitioner's comprehensive representation, so also the views adopted by the Honorable Writ Court, like consideration of the writ petitioner's submission before issuing the order of resumption of the land such and such. The writ petitioner is hereby directed. Now, my lord, this is important. Directed to submit one comprehensive plan regarding utilization of the leasehold land within 1 week from the date of receiving this order, failing which the order dated 8 December 2022 will be given effect to on stricto sensu manner, and further deliberation will be made subject to receipt of this comprehensive plan as indicated here above. So I also directed to give in a comprehensive plan. But kindly see, plan was submitted at page 132. Is the forwarding letter. Entire plan from 133 to 135. I have submitted. Their main thing which they require is 134. Time required for construction of the premises. That is the sine qua non, because lease deed says you have to comply with the specific time. That time they have condoned, asked me to give a this plan. I have given this. Thereafter, nothing done. But I made a representation again, 136.
Yes.
138 is the notice for hearing. Oh.
Yes.
Now, my lord, kindly come to 142, the order.
Impugned order?
Impugned order. 142.
Yes.
My lord will fail to consider any plan has been considered of mine. Nothing. It says no satisfactory result has come out on perusal of the comprehensive plan. If you don't accept my plan and give a direction, how can I execute it? I'm asking the question to myself.
Where is this act?
This is a soft case, my lord. If today they accepted, say they will do it this time.
Yes, I get it.
My lord, the land was allotted to the petitioners 20 years back.
We will not go that far.
My lord, let me, my lord, first clarify the point.
No, please don't clarify, because the court has directed you to act in a particular manner, right? It is you who heard it and directed the petitioner to come up with a comprehensive plan. Now you say whether you accept or you don't accept. If you don't accept, the reason for non-acceptance or how it can be cured, because your idea was to permit the petitioner to possess the land because of the virus and all these things and everything, because you have condoned it. You have condoned it. Had you said, I will not condone, I reject it in the very first place, it is all over. But what you do, you admit that yes, there are reasons for which the petitioner is facing hardship, and accordingly you give one opportunity to the petitioner to submit one comprehensive plan regarding utilization. What is your idea of utilization of this land? The petitioner has given a plan. Why don't you come up and say that this is to be done, this is how it has to be done?
Conditions, so that I can
My lord, the lease deed clearly provides
that
what
is
has to
over.
be done and what is not to be done.
Tell him, let him know.
My lord, in 2006 itself, it was clarified he has to construct a commercial and residential complex there. In 2006 itself, he was granted
You tell them he has given a plan. He has given, what does he say? In the plan, has he said that I am not going to act in accordance with the lease deed, the terms and conditions? Have he said that?
What I understand, my lord, but kindly appreciates, my lord, even after the opportunity was given to him, thereafter also no construction was taken.
How can I?
You accept it first. Your order is in December. What is the date? In February. 28th of February. 6th of March is the submission of the plan. And you pass the impugned order of determination on 10th of January 2025. Right. From 23 till 25, did you intimate the petitioner that yes, I am accepting your plan? This is the way you should work.
But they were called for a hearing.
Yes. October. Yes, in the date of hearing is August.
Good.
No, December 24.
It's at the date, it's dated 5th of December 2024.
Yes, the date of hearing is 17th of December 24.
My lord.
Right. But then did you intimate that you accept the plan proposal which has been submitted by the petitioner?
My lord,
The petitioners are taking.
My lord, in the order impute, my lord, it has been made clear that we are not accepting it.
In the order impute means this notice of determination.
My lord.
So now they get to know.
But having said that, my lord, but the point that from 2006 itself, they had to complete it in 3 years. We issued a notice in 2012.
Sir, please do not open it.
My lord, and on the earlier round of litigation, the points were kept open, whether we'll accept it or not.
You accepted. The moment you accept.
We have not accepted it, my lord. We have not waived our right.
You have permitted the petitioners to come up with a comprehensive plan for utilization of the land.
My lord.
What does this mean? That means you condone the delay on the part of the petitioner. You only say, I can understand that the plan proposal was submitted on 6th of March. Thereafter, what did you do? 6th March 23, the next communication is from the petitioner's end, at least that is annexed to the writ petition, is of 27th of August 2024.
My lord.
Right. Why did you not intimate the petitioner whether you accept the plan or not? In March, now you say that I am not extending the time period. In the meantime, 2 years have already elapsed.
I need to take instruction, my lord. But the matter is, my lord, has been upgraded.
That is all right.
So,
that is all right. You take instruction. No difficulty. But the court has made its mind clear. It is because of your latches that the petitioner is getting this extension. Had you intimated the petitioner immediately in March 23 that yes, I give you 2 months, 2 years time to conclude the construction, he would have been out by now. You don't do that. You keep the plan with you, and it is only in January 25 you intimate that no, your lease is determined, and taking back all the old stories, which you cannot do. Please come back.
By the order with me, I should not speak. This is our teaching, but I will only add, my lord, if you also see, they now cannot say that I cannot. They condone the lapses.
The petition is aggrieved by the notice of determination of lease dated 10th of January 2025, issued by the Special Officer of Urban Development and Municipal Affairs Department, whereby possession has been directed to be taken back on 24th of January 2025. Stop. Paragraph. Learned advocate representing Asansol Durgapur Development Authority seeks time to take instruction. Stop. Paragraph. It appears that an earlier notice of resumption of land was directed to be kept in abeyance by the court. In the earlier writ petition filed by the petitioner. A video order dated 20th December 2022 in WPA 28248 of 2022. Stop. Paragraph. The court granted liberty to the petitioners to submit a comprehensive representation, and the respondent authority was directed to consider and dispose of the same after affording an opportunity of hearing. Stop. The petitioner was duly heard by the authority, and an order was passed by the Chief Executive Officer of ADDA on 28th February 2023 by observing that, considering the hardships faced by the petitioner, and also in view of the views adopted by the Honorable Writ Court, the writ petitioner is directed to submit one comprehensive plan regarding utilization of the leasehold land within a week, and further deliberation will be made subject to the receipt of the comprehensive plan. Stop paragraph. The petitioner submitted the comprehensive plan on 6th March 2023, but there was no deliberation from the end of the authority. Stop. With a communication dated 27th August 2024, the petitioners sought to inquire about the fate of the comprehensive plan submitted by it. Stop. The petitioner was heard on 17th December 2024, and the impugned order has been passed on 10th January 2025, determining the deed of lease with a direction for taking back possession on 24th January 2025. Stop. The petitioner is aggrieved by the same. Stop paragraph. Prima facie, it appears that that ADDA ought to have intimated the petitioner the fate of the comprehensive plan in terms of the order dated 28th February 2023 passed by the Chief Executive Officer. Stop. Despite the petitioner submitting the plan within the time period framed by ADDA, the petitioner was not made aware as to whether the plan proposal submitted was accepted or not. Stop. Till a formal acceptance is made by ADDA, the petitioner could not have proceeded with the work. Stop paragraph. In view of the above, the decision to determine the lease and resume possession is liable to be interfered with. Stop paragraph. To allow the learned advocate representing ADDA to come ready with proper instruction, the writ petition stands adjourned till uh, 10th of February 2025. Stop. There will be an interim order staying operation of the impugned order dated 10th January 2025 till 28th February 2025 or until further order, whichever is earlier.
I take to appear for the petition. It is a very innocuous prayer, my lord.
May it please your lordship, I appear for the Union of India.
What had happened, my lord? The petitioner had been granted a license to operate a cycle garage at Lokhikantapur 3, Station 3 by the Eastern Railways. Now, the term of contract was for 3 years, which is deemed to expire, my lord, on 23rd of January 2025. My lord, if your lordship may kindly see the initial contract at page 29.
Yes.
Lordship may kindly sees at page 29, the last para, the validity of the license. Subject to the terms and conditions contained in this indenture, the license shall be for a period up to 3 years, commencing on and from 24th.
Yes, it is all right. So your term is expiring tomorrow.
Yes.
Then how are you aggrieved?
I am aggrieved, my lord, because I had made an application for renewal. Initially, it was not considered. Then I had filed a writ application pursuant to the direction of your lordship. They had considered and rejected my application, my lord. only on one ground. If your lordship may kindly see the impugned order at page
P10.
At page 40.
5
the
and
relevant portion is at page 46.
Yes.
6 and 47, my lord.
বলছি দাঁড়ান। The reasoned order starts from page 45. Your lordship may kindly seize the impugned order. While passing the impugned order, they have referred to the terms of the contract, validity of license. If your lordship may kindly seize from the third paragraph onwards. Here, my lord, if your lordship may kindly seize, initially the contract does not say that the renewal only shall be only for 6 months, and that too subject to certain conditions. But my lord, to improve their case, what they have done, they are referred to another guideline, which is a non-statutory circular, where, my lord, it has been stated that a guideline had been framed on and from 2016, where a minimum period of 6 months shall be allowed for renewal, and that too subject to certain conditions. I humbly submit before your lordship, when the contract initially had been framed, my lord, nowhere it had been stated that the renewal shall be for 6 months, and that too under certain conditions. I would have understood if they said, it is my option, I'm cancelling. But they're referring to a guideline which was never mentioned in the contract.
My lord, at the same page.
Non-statutory circular.
Sorry, man. I beg your pardon.
My lord, in this regard, my lord, may I refer to a judgment, my lord? This is Maharashtra State Electricity Distribution Company Limited versus Ratnagiri Gas and Power Private Limited. Your lordship may kindly seize the legal position, my lord. I shall not trouble your lordship by citing all the facts. Your lordship may kindly seize at paragraph 35.
Tell me, did you participate in the fresh auction process?
I did not, my lord.
Why?
Because, my lord, your lordship had directed them to consider my application for renewal. If I participated, my lord, then my application for renewal would have gone.
What? It could have been done simultaneously.
Yes, ma'am.
You could have preserved your right.
Yes, ma'am.
Lordship.
How can you say that it is they will be bound to renew the contract? You cannot
I'm
say
not
so.
saying that, my lord.
Then
I'm not saying that.
Then
I
you
am
ought
saying,
to
my lord,
have.
they have invented a new reason, a guideline which was never, my lord, stated when I entered into a contract. So I had legitimate expectations, my lord, that my application for renewal shall be considered for another 3 years. And on that understanding, I had invested a huge sum of money in renovation, my lord, of my parking lot.
Your initial contract is at page 29. You just now read out.
Yes, my lord.
See page 30, the first few
Yes, my
lines.
lord.
Terminating on the 23rd of January.
Yes.
Further renewable after completion of 3 years with 10% enhancement of the thereafter at the option of the. So this option was always there with the administration.
My lord.
It was never your right to get it renewed.
Your lordship is absolutely correct.
They have exercised their option.
My lord.
Then it is there. You cannot say that it is a new clause.
My lord.
They have exercised their option, my lord.
And it has
by
it is
referring
the
to a
agreement-
guideline.
And it is the agreement signed by them.
Please come.
Sure.
The petitioner is the existing contractor for a license, which was for a period of 3 years, commencing from 24th January 2022 till 23rd of January 2025. Stop. The contract was renewable with 10% enhancement in the rate of the license fee at the option of the administration. After completion of the contractual period, the licensee is responsible for peaceful handing over of the possession of the railway land to the administration. Achha. In the instant case, the contract of the petitioner was not renewed. Stop. Fresh auction has taken place. Stop. The petitioner has not participated in the same. On the legitimate expectation that his contract will be renewed for a further period of 3 years. Stop. Paragraph. The prayer for renewal made by the petitioner stood rejected by the authority. On the ground, authority relying on the policy guidelines issued by the zonal railway on 14th of January 2016, which mentions that the extension of the existing contract should be avoided by proper advance planning. Stop. However, in unavoidable and exceptional circumstances, for ensuring uninterrupted services of parking to the passengers at the station, subject to the willingness of the contractor, extension of the existing contract may be considered for a maximum period of 6 months with 10% hike in the license fee for the extended period on pro rata basis with divisional finance concurrence and approval of the DRM. Stop. Such exceptional circumstance may arise when the open tender is floated in advance but could not be finalized due to unavoidable administrative circumstances or due to poor response. Stop. Paragraph. In the instant case, it appears that the authority proceeded with the fresh auction and has not renewed the contract of the petitioner. Stop. Paragraph. The petitioner cannot claim the renewal as a matter of right. Stop. The same is always at the option of the administration. Stop. The administration has opined not to renew the contract. Stop. The court does not find any error on the part of the authority. Stop. The writ petition is devoid of merits. Stop. It accordingly fails and is hereby dismissed. Service is taken on record. Remove. Yes, next one.
Yes. Ladyship, this is my application, milady. It was placed upon obtaining leave from your ladyship. Now, ultimately, at the end of it all, the petitioner before your ladyship today is engaged in purchase and selling of birds. Now, these birds I have been purchasing and selling. Now, there has been a brief history, probably, of the whole facts is supposed to be narrated before your ladyship.
If you can be a bit short, because time is
Ultimately,
very
I am
precious.
challenging cancellation of my application for rejection. This cancellation was your ladyship informed to me through an email saying that it has been rejected. No order of rejection has seen the light of the day against me. There is, of course, there is being no order, there is no reasons. So I challenge this cancellation or rejection on that very ground that
What you want? You want to hold the birds?
Yes, that is there, and I'm supposed to. Nobody is stopping me from holding the birds, except for I have been now saddled with the responsibility of registering the possession of those birds with me.
You do not want to register?
Yes, I want to register. I had applied for registration. Now
They
that
have
has been
refused.
cancelled. Yes, refused. Rejected.
Did they register it earlier?
Yes, some of them are pending. Some of them have been again rejected, which could not be rejected, as has been held by our one coordinate bench of this honorable
Alright.
court. There is a history behind that.
All right.
Today,
Show me the order of rejection.
160. Your ladyship may kindly.
162.
Page 162, 160 to 167. These are all one-line order. Your application under the living animal species 2024 has been rejected after hearing on Parivesh portal. Your application number is so and so.
Hearing on Parivesh portal, was there a hearing given?
No, I was called for hearing, attendance register signed, no hearing has been given. That I have contended. And in any event, the order.
Show me this rules one.
Yes. Rules are the 2024 rules are the.
May I respectfully hand over a copy?
Species reporting and registration rules.
I have handed over. I have handed over.
Your
Yes.
ladyship will kindly come to 8. Rule 8. I'm keeping it as short as possible.
Yes, rejection.
The management authority or the authorized officer shall reject any application if not found complete in all respect. The management authority or the authorized officer, if the provisions of resolutions of the convention are not satisfied, or any provisions of the act or rules made thereunder have not been complied with, or a false information is furnished, may refuse after duly considering the recommendations in Form 3 or cancel the registration as the case may be, after providing the applicant with the opportunity of being heard, which I say has not been granted to me.
But then I see section rule 10 and provision for appeal.
Yes, I'll come to that also. Before that, your ladyship kindly takes up rule 9.
Yes.
Every order of management authority or the authorized officer shall be in writing and shall be signed and dated by him. Forget about complying with this. The order is not communicated to even me. Only the fact of rejection is communicated to through a email communication. There is no order. And since there is no order and there is no reason, I cannot prefer an appeal. That is point number 1. And point number 2 is, who will be this appellate authority of the central government? I had made representations. I had made RTI applications before the appropriate authority, which your ladyship will find at page 168. There is no reply to it. I do not know where to go. I do not know against what to go. So this remedy is illusory.
May prefer an appeal to the central government within a period of 60 days.
Yes. First thing is, there should be an order so that I can know what are the reasons of.
All right, let me hear the Government Union of India. Yes.
They are the it is our order, Lordship.
Page 162, I see the Government of India, New Delhi is mentioned.
My lord, what happens is, this is a portal which communicates.
Portal which communicates.
My lord, we can appreciate, and it is the respondent number that who has been delegated.
Chief Wildlife Officer and
Chief Wildlife Officer, that is respondent number 8, has been delegated with the power of giving the hearing and passing a reasoned order, which is being represented by my learned friend.
All right, Chief Wildlife Officer.
Now, let my learned
yes, then yes.
Then I will make my submission.
Lordship, the order was preceded by hearing notice.
Hearing notice.
Lordship.
Not a hearing.
No, he attended. Lordship, may I respectfully invite your Lordship to page 159.
Right.
So, my lord, kindly have a look, my lord. He had preferred as many as 18 applications. Kindly, my lord, have a look at the top at reference.
Is it that one application for one animal?
Lordship.
That
so
means...
he preferred, my lord, 18 applications. Kindly see, my lord. Our rejection counts, my lord, in respect of only 8 out of 18.
All right.
This was communicated. My learned friend was referring to one provision of the rules of 2024. That is rule 9. Every order of the management authority or the authorized official shall be in writing and shall be signed and dated by him. Lordship, now Lordship knows, my lord, it's electronically, my lord, signed, my lord, and it is sent to him.
Where is the order?
On the portal, Lordship.
Where is it? I want to see. Where is it? Is there a formal order of rejection?
No.
Or is it only communication of the status that it has been rejected? Where is the order of rejection?
Normally, it is uploaded on the Parivesh portal, but my lord, off the cuff, I don't want to make submission, my lord.
Partially correct that it is uploaded in the Parivesh portal, but again, fact of rejection, no order.
Where is the order? Some grounds must be given for rejection, because Rule 8 says that these are the grounds for rejection.
Lordship, may I seek for one instruction, whether any order, text of the order,
yes,
is there or not?
Certainly.
Lordship. If not, my lord, then it has to be relegated.
Delegated.
I fully agree.
My lord,
when?
One more point. That's the heck of it, I'm making this submission, my lord. This communication was made way back in November. My lord, kindly see that.
November 2024.
Yes,
2
November
months is the date
21.
of preferring an appeal.
Yes.
Sitting tight over it, no, they could have.
I am
proposed
within
to be
time.
On this ground only, they could have come up with.
No, ground also, the appellate authority is the central government. Is there any specified officer? Who is the specified officer?
Management officer.
Your ladyship, I had asked for
Only the
it.
central government. 1 minute. Only the central government. Who is the authorized officer?
The authority, who is the appellate authority, will be there, Miller.
Who is it?
We will come up with the instruction.
It's the same thing. Please come.
I'm wondering
What were you doing for so many days?
I'll explain. First thing is I tried to find out exactly what has now fallen from the learned advocate.
And you took so many days?
No,
60 days will be over.
No, I had filed on the 60th day within limitation.
Yes.
That is why.
60th day.
Why? Because I had preferred an application for knowing who is the authority.
Where is it?
Yes, the 168. 168 to 172. 172 being the and 171 being the article track records. These went unanswered. So I waited till the last day to know whether I have actually there is a authority available to me to ventilate my grievances before I trouble this honorable court. But
the petitioner is aggrieved by the rejection of his application under the living animal species bracket open reporting and registration bracket close rules, 2024. Stop. Specific allegation is that no reason for rejection has been intimated to the petitioner. Stop. No order of rejection in line with Rule 8 of the aforesaid rules has been passed or communicated to the petitioner. Stop paragraph. To allow the learned advocate representing the concerned authority under the rules and the learned counsel representing the central government to take proper instruction in the matter. The writ petition stands adjourned till Friday. Will it be all right?
Sure. No, tomorrow is holiday, Lordship.
Or telephonic instruction. Tuesday.
I want to take my written instruction.
I also, my lord, because I'm also in a soup now in one matter, my
Tuesday,
lord.
Wednesday.
An order was given.
7th, my lord, 14th.
Then it will go back before the regular bench. Because is
no, it's your lordship.
Oh, this is interminate.
Group 9.
Very well.
Monday.
Monday is 27th.
We are the main answering whether text of the order is available or not. If not, lordship will relegate.
Wednesday. I'll give you 1 week time, 29th. 29th. Okay. Specific instruction shall be obtained as to whether a formal order of rejection was at all passed, and if passed, whether the same was communicated to the petitioner. Stop. Whether the grounds for rejection are mentioned therein. Stop. And the appellate authority as per Rule 10 of the said rules.
No, whether it has been uploaded in the portal or not.
Portal.
What thing?
Portal.
Portal.
Order sheet to be, my lord.
If it is uploaded
on the portal.
In the portal, my lord, then they were privy to it.
Not personal communication, on the
Very
portal.
well. Come up with that also.
Lordship.
That will also suffice.
In the meantime, your ladyship, may I point out, for infraction of any provisions or registration, there are penal consequences which can be invited. To that extent, till the next date, they may be protected.
Let the respondents are restrained from taking any coercive steps against the petitioner till 31st of January 2024 or until further order 25 or until further order, whichever is earlier. Yes.
Extremely.
12. Yes. Affidavit of service to Rekidin. 12.
Only one thing, probably it has gone down as 2024 instead of 2025.
25. I'll check.
I appear for the petition. I'm led by Mr. Yes. But the item number 12, my lord, I appear for respondent number 8.
Yes.
Well, I believe item number 12 and item number 14 are more or less identical.
Right.
Only difficulty is that, my lord, item number 12, my lord, whatever has been served yesterday at about, my lord, in the afternoon, and 14 has been served at 4 p.m. So if Lordship kindly takes it up day after tomorrow, it will be very
You are for the respondent number?
8.
Which respondent you said?
My lord, 8, my lord, 8, PDCL, my lord. Power Development.
Oh, Power Development Corporation. Are you the answering respondent?
Yes.
Your grievance is against PDCL.
My grievance is against the environmental authorities.
Environmental authorities. Who is representing?
Mala, we do not know. Mala. MOEF has been made a party, I believe.
Yes. And they have been served.
Mala, I think Jishnu আমাদের সাথে
এত ভয় দেখাও কেন?
Who is for the state?
এইদিকে পার্থদা বিকাশদা ভয়
I didn't hear.
I am led by Mr. Shishchandra Bandyopadhyay.
Yes.
Senior Standing Counsel.
For the state.
We have received the intimation very late evening yesterday.
Yes. Department of Industries and Commerce. Power. Environment will be taken care of. Director of Mines also possibly.
Yes, my lord. Director of Mines is state authority. State.
Chief Mining Officer. State level Environment Impact Assessment Authority. This
MOEF has to be served, my lord. MOEF, Ministry of Environment, Forest and Climate Change.
9. Government of India.
Yes, because my lord, the environmental clearance has been issued by MOEF.
Did you serve? Has the respondent number 9 been served?
Yes.
Through email we have served and we have sent also through post.
Where?
Both.
Why? 11th Strand Road office is over here. You can go and serve over there. Serve 11th Strand Road. It's there.
Yes,
Why?
yes.
You can
Yes,
go and
Union of
run,
India.
serve, and you serve through post.
Present generation has been more used to email than us. We used to send our clerks, serve it there.
Union of India can be served, my lord, in the stand road, my lord. That can be done. But kindly keep it on.
Are you praying for any interim order, immediate relief?
I do not think so.
Immediate
the
relief in the
petitioner
sense, I
say.
tell you, Lordship. A news item came out in the Times of India saying the government has sanctioned this excavation of the basalt mine in the first week of February.
Which government? Central or
Yes,
state?
state government.
State government.
State government.
All right.
And the chief secretary has said this in press that the next first week of February, the work will commence.
Yes, state. What is your response?
My lord, I need some time to seek
Well,
information.
kindly keep it on Monday. We will come back with adequate instructions.
First week of February, very well. To allow all the parties. 24th is Friday.
Yes.
That day we are not available.
Service will be affected.
To allow the learned advocates representing the respective parties for the respondents to come ready with proper instructions. This is the same on 24th, Friday. Let service be effected upon the non-appearing respondents, intimating the next date of hearing.
24th
Friday.
24th,
You are there for the state.
Just now I came to that.
Mala, kindly keep it on 28, Mala.
কেন 24 থাক না দেখো না তুমি পেয়েছো দেখে পড়ে নেবে
24 তারিখও আসবে না
কি আসবে না কেন কি হচ্ছে কার বিয়ে
24th is a
ওর বিয়ে না জানি কার বিয়ে তাই
আমার বিয়ে আর হবার নেই
না না এখানে অনেক সময়
There is a request not to keep it next week because the learned council will not be there. Come up with a consensus date. I do not have any difficulty.
ওর সাথে সাথে রাখতে থাকবে
29
হতে পারে
দেরি হয়ে যাবে অনেক দেরি হয়ে যাবে
29th?
মাঝখান থেকে খোঁজাস কেন অনেক
আচ্ছা বুধবার 29th করে দিন
সব ব্যাপারে কথা বলা
29th.
with high hope that everybody will be present on that day and no adjournment shall be paid for.
No.
I don't know.
Usually, my lord,
Actual aspects not very important.
yes, legal points are involved. Therefore,
Grateful, man.
13. Huh? Appearances গুলো দিয়েছে Item 12 and 14 appearances should be given.
Yes, yes.
Yes.
Appearances, please give item 12 and 14.
Yes, right.
Yes, 13.
Very good. Okay.
Sir, affidavit of service.
আপনি দিয়ে দিন না।
লিভ নিতে হবে স্যার ফাইল করার জন্য।
You are a publisher.
I'm a publisher. Lordship,
You made application within
I made application on 3rd of October possibly.
right, and stall has not been allotted to you.
Lordship.
Are you the first time participant? Or are you the first time participant?
No, Lordship, I participated
In the earlier occasions also?
Previous year. I have annexed documents to that effect.
All right. Just let me hear.
It's just that it wasn't possible to be scrutinized. They were finding that it's not of a very not of a very high standard. That's why it was not allotted to him. There is no other grievance against him at all with respect to it.
We setting the standards. We say
No, thing is, it is their fair. It is they who can set it. Still, till the court comes to an opinion that they will be amenable to the writ jurisdiction, the court cannot interfere.
Lordship, let me make my submissions. I'll be very quick. There were two sets of submissions, one by the learned advocate general and another by my learned friend. Lordship, according to the learned advocate general, the state does not sponsor the fair. It's only a facilitator. And how does it facilitate? It facilitates by providing the ground, by providing the electricity,
Infrastructure.
allied
Infrastructure.
infrastructure and all these things. And according to the learned advocate general, it is a cultural part of cultural heritage of Bengal. And therefore, even if the state sponsors it, he possibly brought in the comparison of making donations to the puja committees. The fact that the government makes donations to puja committees does not make them a state under Article 12. Lordship, on the other hand, it is the stand of the book fair. Now, there's another point which has been also agitated canvassed by the learned advocate general. That is, the Editors Guild, as far as the book fair is concerned, is not a monopoly. It's not a monopoly. Lordship, this I believe needs some factual clarifications. As far as Kolkata Book Fair is concerned, the masthead Kolkata Book Fair is concerned, it is a monopoly. For the last 48 years, it has been held by Editors Guild only. The Kolkata Book Fair, as it is popularly perceived, is organized by. On the other hand, it has been the submission of the guild that they are a private body, and they don't have a system. They don't have a system of sending communications to applicants saying that we have denied you, and so on and so forth. Lordship, my simple submission is that essentially, what is a book fair? A book fair is, if it is looked at from a wider perspective, it's basically a cultural awareness program. It is a cultural event. There's no doubt about it. There cannot be any measure of doubt about it that it is a cultural event. A great cultural diffusion takes place in the book fair. And the book fair, the real bibliophile doesn't really buy books from the Calcutta Book Fair. The bibliophile goes to the Calcutta Book Fair to look at the fresh titles that have come up and makes a list of the books that he is going to buy, because the discount that is given by the book fair, the stall owners of the book fair, are much less than what is available in the market. Right. I am a publisher with 300 books published by me. I have published 300 books, Lordship. You also hold little magazine stalls where people from the suburbs or the little magazines, they come and sell their books, sell their wares. So if according to them we are not up to the standard, let us tell us. We'll try to fit in the standard, Lordship. Let us let
No,
them tell us.
it is the same thing that you submitted, that who is going to set the standards?
Who's going to set
By
the
their standard, they feel that you are not up to their mark.
Lordship,
You say you may be
great-
better than
great-
that also. But
you
then
have
why
this-
will the writ court enter into all
you
these
have
things?
this great public participation, and you don't even know what are the standards. You don't even publish it. You don't even
Now,
publish it.
see, this is
Then I'll try to fit in with the standards.
standards of the book cannot be marked mathematically. Arithmetic
It's
standards
not a
cannot
question
be
of standard
set.
of books. I don't think anybody has gone through 300 books. I don't think anybody could possibly go through 300 books.
You have gone through more than that.
That I have.
But the way I can't force every bookseller to come and get into blood like Bahari Sons. They are famous all over India.
I would only request my friend if I could possibly be accommodated. I only request my friend.
I don't know whether
He
any
can
such
put in his
request will be accepted or not. I do not know. The court will not enter into this.
He can put in his words, Lordship. I'll also request the learned advocate general
What
if you
will
could
they-
possibly accommodate.
What will the AG do? He doesn't have any role.
No. He can always keep his hand on his shoulders.
That is something
That is
different.
what that is
Because
what.
that hand can go both sides. Not only on the right, it
What a
can
hand.
go to the left also.
This is the best possible argument.
What to do? Heard submission made on behalf of the parties. List on 27th.
The inauguration is on the 28th.
With regard to this, no legal submission made. A request. So I'm just keeping it on the 27th. No order will be passed. If you can take steps, fine. If not, whatever will be passed in the other order this will abide by that.
And to Milord, communicate to my senior members to your option. This year may not be maybe a little difficult, but next year I will.
No, please.
No via. It has to go straight. Please. Call the next one, please. 14.
Milord, I am for the petitioner, Milord.
15.
Milord, I am for the petitioner. Milord, what happened, Milord? An order, Milord, has been passed under Section 10, Milord, under the Highways Act. Now, Milord, I have already preferred an appeal. Now, Milord, 27th, my learned senior friend's client has, Milord, has given a notice they will demolish. My appeal becomes infructuous.
Where is your appeal? Page.
Milord.
Page.
Yes. Milord, I am filing a supplementary affidavit. Milord, I have
Supplementary.
annexed the copy of the appeal.
Initial order is
Yes.
22nd of August 2024.
That is, Milord, the kindly see page 24 of the Milord writ petition, Milord, at page Milord 11. Order has been communicated to us, Milord, on 15th of January. We filed appeal on 20th January.
Order dated 22nd August.
That is, Milord, no. 6th January. 27th August, Milord, it is, Milord, the notice, initial notice of hearing. My Lord is looking at page 72, Milord.
75. I am at page 75. Reasoned order.
Page 80. 6th January. This is the ultimate order. Inspection report not served.
6th of January. Joint inspection received. Sergeant
And page 77. Kindly see page 77.
Directed to take all necessary steps to remove the illegal constructions. 27th of January, positively. And where is your appeal?
My Lord.
6th January's order you received on the 15th of January.
15th of January, we filed down 20th January. That is the supplementary affidavit. Copy though.
Copy.
Right.
21st of January.
And no date has been fixed as of today.
What is the time limit within which it is to be done?
15 days.
15 days. The date of the order, but then if you can Show me that you received it after.
That is, my lord, I've made a specific statement, my lord. Otherwise, I could.
How did you get this? Through court?
No, through the officer in charge of the police station.
To the officer in charge of the police station.
By-
Memo number.
By hand service.
16th of copy forwarded. You are Raghupati Gayan.
And Basudev Mondal. Kindly
Raghupati
comes to page 78, 10 and 11. Page 78, 10 and 11.
Yes, page 80 is the copy forwarded for information and communication. Basudev is there, such and such is there. How did you serve this
It has
order?
been served upon Miller personal service through the office of the officer in charge of the police station.
By post,
No,
nothing came to you.
No.
OC is a different party over here. See, page 80, serial number 7 is the OC.
Serial number 7 is OC, yes.
There is no direction upon the OC to serve it upon you.
No.
It should go to you directly.
Directly, but we have been served through the officer in charge.
On the 15th.
On 15th.
Mr. Bandyopadhyay. Please come.
Already filed, my lord.
Being aggrieved by the order passed by the subdivisional magistrate Baripur, South 24 Parganas.
This 27.
Date বললাম কি? Dated 6th January 2025. Directing the assistant engineer, PWD within bracket roads, Lokhikantapur Highway Subdivision, to take necessary steps to remove the illegal encroachments. And complete the demolition process on 27th January 2025. Stop. In the paragraph, the petitioners allege that the order dated 6th January 2025 was communicated to them through the officer in charge, Bokultala Police Station, only on the 15th of January 2025. Stop. The petitioners filed an appeal before the district magistrate on 21st January 2025 within the statutory period. Stop. No date has been fixed by the appellate authority for consideration of the appeal. Stop. Paragraph, it has been submitted that prior to disposal of the appeal, if the encroachment as alleged is demolished, then the appeal will be rendered infructuous and the petitioners will remain remediless. Stop. Prayer has been made to stay the hands of the highway authority from proceeding with the demolition process. Paragraph. As it appears from the submission made on behalf of both the parties that the appeal which has been preferred within the statutory period is yet to be considered and disposed of. Accordingly, the court is inclined to direct the respondent authority not to proceed any further with the demolition process till the conclusion of the appeal. Stop. Next. The district magistrate, South 24 Parganas, being the respondent number 2 herein, is directed to consider and dispose of the appeal preferred by the petitioners in accordance with law at the earliest by passing a reasoned order. Stop. Till 1 week after the date of communication of the reasoned order to the petitioners, the impugned order of the subdivisional officer shall not be given effect to. Stop. It is made clear that the court has not entered into the merits of the appeal preferred by the petitioners, and all points are left open to be decided by the district magistrate at the time of consideration of the appeal. Disposed. Supplementary affidavit filed in court is taken on record. Service is taken on record. For it,
I'm for the petitioner.
Yes.
Service.
Who is your other side?
There are 4 respondents are there. This matter was
Did you
mentioned.
serve the GP's office? GP's office did you serve?
No, Your Lordship.
Why?
We have sent through mail.
No, your mail service will not do. You have to intimate the GP. Who is the answering respondent? State Fisheries Development Corporation.
Your Lordship.
WB ACDCL. Nobody there? ACDCL? Please come. None represents the respondents.
Your Lordship.
Affidavit of service is taken. Do you seek any immediate relief?
Yes, Your Lordship.
What?
Your Lordship, the state fisheries, they are threatening us with disconnecting the power supply. Now, the state fisheries, they take the electric supply from WBSCCL and they give the other occupants there, business holders, through submitters. Now, I've been paying the electricity bill at the earlier rate continuously, but they have arbitrarily increased the amount. And the bill has increased so much that I have already communicated them. They did not reply to any of my letters.
Very well. I'll take it up on Friday.
Your Honor, that they have given
Lordship,
a
kindly take
15
it
days
Friday,
notice. 15 days notice on the 8th. 23rd is the 15th day, Your Honor.
It doesn't matter because your other side is not there. You could not ensure service properly. At least somebody from the GP's office should have been here.
I'll serve
Right.
them today.
Please do serve the office of the GP and ensure service upon all the other parties also. I am fixing it upon day after
Honor, I've
tomorrow.
already, it has been accessed. I've already submitted a report. The mail has been accessed. No.
Maybe. Service is taken on record, list on 24th. Call the next matter.
May it please, Your Lordship, Lord.
Lord, I am for the response.
Yes.
Lord,
Take an instruction.
yes, Lord, I have also
Well,
taken
the
instructions, my Lord. I believe-
RGRO had already passed an order. Against that, your Lordship knows, my Lord, the appellate provision is there, Ombudsman.
Lord, I believe,
So,
I tell you, Lordship, Lord, I believe, Lord, I have got a very good case. I need only 5 minutes to explain what is there. My Lord, in 1995, all are orders of court. Lord, it is annexed as a part of the matter. My Lord, in 1995, there was some.
All these grounds that you seek to raise over here can be raised before the appellate
Now, Lord,
authority.
the problem is,
You have got the order
I have to protect my right, not the connection. Then only I'll go to the ombudsman. I have already paid amount which is not liable to be paid by me. Just give me 2 minutes time to show me, Lord, that I have a prima facie case. Just 2 minutes time. Only 2 minutes I'll seek. Lord, kindly come to page 192. Just 2 orders of the High Court. 190.
You have showed the orders yesterday.
No, this order I have not shown. I'll come to 192. Lord, in 1992, they raised a provisional bill which was challenged by me before Justice Somores Banerjee. His Lordship, Lord, protecting my right, relegated me to the authorities, saying that you raise a dispute case. 192 kindly comes.
Yes.
Kindly take 193. This is an order, Lord, dated 12 July 1995. Kindly come to 193. The petitioner shall raise a dispute within a fortnight from the date before the Chief Electrical Inspector, taking all points therein and specifically referring therein the bills in respect of which is raising the such dispute and reasons thereof. The Chief Electrical Inspector or his nominee within 3 months from the date of raising dispute shall adjudicate the matter. Lord, I raised the dispute. Kindly come to page 195. The authority decided in my favor, rejecting all their claim. Come to page 196, the order. 196, last paragraph. Maharashkali got that? 196. This is an order dated 7th May 1999. Kindly see what the authority says. Same authority which has passed the present order. From the record submission, it is observed that the consumer hotel so-and-so found financially problem due to the delay in condition due to the approach of the WBSE board, wrong estimate, defective meter, so-and-so. Considering all these factors, it is ordered that the WBSR board will revise electricity bill till previous bills by taking our care of average 144 unit from 3 months, 432 units for 9 months, and disputed period that is from March 95 to April 95, April 95 to November 95, and test results remove dispute from December 1995 till the date. Turn the page. Till the date the meter is replaced. Then next para. After preparing final electricity bill, considering proper rate allowed from June 92 to December 1997 till the date of exact meter, WBSCTCL board will arrange for adjust the extra amount that is received by them from the consumer. After preparing such bill, the board will not charge any late payment fees. Now, this is the disputed period from 92 to 97. Now, against this order, they went up in appeal before the appellate authority. Now, kindly take that order at page 198. Appellate authority by an ex parte order remanded the matter back to the chief engineer. Page
by setting aside the order of electrical inspection.
Page 202. Lords, remanding back means setting aside. Lord, that much I kindly come to 202. Order that the order dated 7th May 1995 by the Chief Electrical Inspector in adjudicating the dispute of electricity bill raised by the Hotel Seacoast is set aside, is not being in pursuance to the guidelines framed by Justice Somotes Banerjee. Matter is sent on remand to the Chief Electrical Engineer for adjudication. Matters got that? After this order, they raised the demand 203. 203, their period is from April 96. Kindly see the subject. Subject is payment of outstanding dues in respect of Hotel Seacoast as per the order of the appellate authority. Then as per the appellate authority, they raised a bill of 8,69,000. Next page, 204. Now this order of appellate authority was challenged before Justice Ashok Ganguly at page 141. Justice Ashok Ganguly set aside the order of the appellate authority. Page 141. Kindly come to 141. Order dated 21st September 2000.
Yes.
Now kindly read the first lines. It appears that the petitioner is aggrieved by the order passed by the appellate authority dated 24th June 2000. That's the order that I have shown. Then kindly come to the concluding portion. At page 143. The court finds that the matter for hearing before the appellate authority on 16th October at 3 p.m. the petitioner must be present on that date and the petitioner will not take any time. This court is fixing the matter in presence of Mr. So-and-so. Appeared, therefore, neither the notice will be required. Similarly, a notice will be given to the board. Board is therefore represented. It will be construed that as the sufficient notice. Then kindly take the next one. Neither the writ petitioner nor the appellate authority order is decided on merit. So, all points are kept open. Writ petition is thus disposed of by impugned order. Impugned order annexure M is quashed. Appellate authority order is quashed. Since the impugned order annexure N has been passed on the order of the appellate authority, the same cannot be given effect till appellate authority decides the matter afresh. So, what is the position? Chief Electrical decided in my favor. Appellate authority altered. High Court set aside the order of the appellate authority, directed him to decide afresh. Nothing has been done in last 20 years. Nothing has been done in last 20 years. Suddenly, May 2024, they raised a bill charging 8,66,000, adding as outstanding. May 2024, for the first time after 20 years without adjudicating the earlier matter.
The appellate authority
Never adjudicated. Never.
The court fixed the date and time.
Never adjudicated. Never, ever. If they can show they have adjudicated, I have no case. Never.
All right.
So after that, May 2024, there comes a bill. My lord, I have prepared a supplementary affidavit so that my lord need not flip over the pages. Kindly take this. তোমারই সব বিলগুলো
বিলগুলো কি হচ্ছে
দেখে না একটু আমি দেখিয়ে দিচ্ছি
ও বিল
Lord, kindly come look from page 8.
Yes.
Just one, Lord, kindly see at the top of bill 8, my lord need not see, my lord comes directly to my lord page 13.
Yes.
Comes to 13. Now kindly see at the top, billing cycle April 2024. My lord has got that. Middle, top.
Yes.
Then kindly see now bottom this side. Here. See here. The current month due is 1,07,622. Outstanding 0. Now kindly see at the bottom of the bill, left hand side, column, bottom. Now kindly look at me here. See, outstanding 8,66,779 for which bill? June 95, July 95, October 95 to December 95, February 96 to 97, July 97 to 98, May 98, November 2000, October 12, 2012, November 2014. These months, they have showed the outstanding. So they decided to charge it after 20 years for the first time in the next bill. Next page, kindly come to page 14. April, there was no outstanding. Page 14 kindly comes. Right hand side, bottom, outstanding kindly see 8,66,779 added. My lord has got that. For the first time they shown. Then kindly take the next page and see late payment charge on the left hand side is 0. LPSC, late payment surcharge. 0.00. Then kindly turn the page. Now the game has started. Now the game starts. Kindly come. June bill.
Which page?
Next page, just the next page. June. Now kindly see at the left hand side bottom, LPSC 6,59,291. So after 20 years, you add the outstanding to the current bill, and next month 6 lakhs is the late payment charge. Hello, got that? Here 6,15,000, and see the outstanding. Outstanding remains 8,51,000, and the current due, including late payment, becomes 8,14,000. Then kindly turn the page. This is not the, and total 16 lakhs. Then next page. Late payment charge 8,18,000. July 8,18,000. Outstanding 15 lakhs. Total bill becomes 24 lakhs. And the order of the commissioner was you cannot charge late payment. That was overruled by the appellate authority. Appellate authority order set aside by the High Court. So that order stands. Now continuously, the next bill.
Yes, I followed.
This late payment is going on. What was being done by Justice Sarkar? Kindly come back to page 15.
My lord, all these points had already been gone into the earlier to read petition by this honorable court.
Let him show that.
1 minute.
Let him show that.
Page.
Now Justice Sarkar from page 15, Justice Sarkar directed us to deposit the principal amount. Page 284 of the writ petition directed that you deposit 8 lakhs in 2 installment of the principal amount. Page 284 of the writ petition.
284.
Kindly comes. He says that it has been decided. Kindly comes. 284.
No, I am not saying it has been decided.
Yes, 284.
Kindly come to page 287. 287.
287.
Para 10.
Yes.
Under such circumstances, 50% of the outstanding dues as reflected in July 4 shall be paid by the petitioner in 2 installments. First installment by September 30, along with connection charges by 24 hours. And second installment November 15. Payment shall be made along with monthly charges raised upon such so. Kindly take para 11. With regard to the other outstanding dues, this court is not expressing any opinion because the writ petition is restricted. Adjudication of all the bills of the billing cycle will be a part of the proceeding before the grievance redressal cell. Now kindly take the supplementary affidavit, how he has decided. Page 5.
Last order page 6.
Last order is the 27th November, page 6. See how he has decided. If he has decided on this, I have taken specific point. Kindly comes statement of the respondent, observation of RGRO, page 6. Heard both parties and scrutinized the document submitted. It is observed that the bill raised by the period of June 95 to 98. The dispute is 95 to 98. On the estimated bills, and the amount comes to 8,64,923. Whereas the bill claimed by the period of August 99 to August 2002, actual consumption bill of 12 lakhs. So the claimed amount to Messrs. Seacoast Hotel is justified against the period of May 95 to May 98, which was decided by the authority. Outstanding amount has been reflected each and every energy bill. The non-showing of outstanding amount as claimed by the petitioner is not valid. Ordered from the above submission and observation, petitioner is directed to pay the pending outstanding bills to LPSC. Now kindly see what the dispute I raised before him, the appeal. Kindly just take one paragraph of the appeal. Kindly come to page 128 of the petition. Justice Sarkar relegated me to the authority. I have preferred a case. What was my case? Page 128. He has not decided anything.
That is why appellate provision is there.
Then it's a perverse order.
128. Yes.
128. First para 18, the order of plot 7th May 1999. Para 18, para 19, the order dated 2nd September 2000, the appellate authority. Para 20, I filed the writ petition. Para 21, Justice Ashok Ganguly's order is quoted. Now kindly see, will not be given effect till the appellate authority decides. Para 22, the petitioner says that thereafter pursuant to the order passed by the High Court, the appellate authority has not taken up the matter.
Now, my lord, the appellate authority is not there. Chief electrical inspector is not there. Act has been changed. So now the RGRO has decided. If my learned friend is
the decision. I want to see where is the decision. Nothing more. Just show me the decision, page 6 of the supplementary. Yesterday you handed over this copy.
Yes.
Where is the decision?
My lord, rightly, wrongly, RGRO has passed an order. Now there is a provision for preferring an appeal.
Please come. If the order would have been at least one line, then the court would not have interfered.
Then your lordships
But
kindly
then-
remand back for fresh appraise. I don't mind.
Yes.
But
It
yes, there
is
is
only this.
Yes,
Not more
I
than that.
I don't mind.
Achha.
My lord is sitting aside.
They've
Not
been saying many things.
Supplementary affidavit.
How LPSC and all these things, that is the statutory provision.
The order of the RGRO and DE within bracket E dated 27th of November 2024 has been placed before this court. Stuff. It appears that a representation was filed before the RGRO in compliance of the direction passed by this court. Stop. The petitioner submitted a detailed representation disclosing several facts and figures. Stop. The RGRO, on consideration of the same, has not referred to any of the facts and the figures as mentioned in the representation. Stop. The grounds set out by the petitioner in the representation does not appear to have been considered by the RGRO. Stop. The RGRO observed that the amount claimed by the authority is justified. Stop. The reason for arriving at such a decision does not appear from the order impugned. Stop. Paragraph. The according to the provisions of the Act, there is an appellate authority before which an appeal is to be preferred against the order of the RGRO. Stop. Paragraph. Learned advocate representing the Distribution Company Limited submits that the petitioner may raise all points before the appellate authority. Stop. The court is not inclined to accept such submission made by the learned advocate representing the Distribution Company Limited. Stop. The same is primarily because of the reason that the order passed by the RGRO is an absolute non-speaking, cryptic order. Stop. Without the grounds mentioned therein, the appellate authority will also not be in a position to decide the appeal on merits. Stop. Paragraph. In view of the above, the court is inclined to set aside the order passed by the RGRO and accordingly sets aside the order dated 27th November 2024 passed by the RGRO and DE within bracket E. Stop. Paragraph. The RGRO is directed to reconsider the representation filed by the petitioner strictly in accordance with law and dispose of the same by giving reasons therefore. Stop. Steps shall be taken in the matter at the earliest, but positively within a period of 8 weeks from the date of communication of this order. Stop. A reasonable opportunity of hearing shall be granted to the petitioner to rely upon documents in support of its stand. Stop. Till 1 week after communication of the reasoned order by the RGRO, the authority will not implement the order that may be passed. It petition disposed.
Lord, the two letters. That is subject to payment of current bill. That is Justice Dr. Pal directed.
The petitioner is directed to continue making payment of the current bills that will be raised by the authority.
Lord, the two notices that I have challenged in the writ petition, page 304 and 305 as a consequence, Lord, should also be set aside.
Automatically.
Because that's a disconnection notice and the demand.
Achha.
This has to go. 304 and 305.
That is arising
As the order of the RGRO has been set aside by the court, the notice of disconnection dated 14th January 2025 and the bill.
Lord, the demand is at 14th January, disconnection 20th January.
Acha, and the that the demand. এখানে কি বললাম আপনাকে RGRO dated 20th January 2025 and the demand raised on 14th of January 2025 stands set aside.
Lord, the supplementary affidavit, my lord, kindly keeps with the record, my lord.
But item number 43, 55, and 63. I understand it will not be taken up today. But they're taken up on Friday, my lord. My junior will be here. My lord, kindly, my lord, take it up anytime, my lord, next week.
I will continue with the urgent motion today.
I will be in some personal difficulty. I'll be leaving the court, my lord.
Yes.
2 o'clock, my lord. And
items?
Item 43, 55, and 63, my lord.
43, 55, and 63. Keep somebody here.
Yes, my junior will be here. And my lord, item number 40. My lord, item 40 on Friday, my lord, the interim order is expiring. This pertains to, my lord, the...
Let it be called on. Please tell your junior to remind me. I'll
Item 68, my lord, kindly recall this, my lord, your lordship is Chachol Bar Association's matter. My lord, your lordship kindly appreciate one thing, my lord, your lordship has passed the order restraining the Chachol Bar Association from, my lord, freely interfering and practicing this. My lord, the others, your lordship kindly recollect this 54 was there. 54 were there, my lord, your lordship's observation, they may have come. My lord, out of them, my lord, the lady advocates, those who have already added, my lord, themselves with the party, my lord, they are now threatening, my lord, to return even the, my lord, today they are here, my lord, this lady advocate, they are, my lord, the modesty may be outraged by them, my lord, that has been threatened, my lord, today. But your lordship kindly appreciate that matter, my lord.
No, but then this has been filed by only one advocate.
Well, that is, my lord, your lordship kindly see the can one is there with
Can one is addition of party?
my lord, addition of party. Let the, my lord, this similarly situated, this, my lord, these ladies
Do
are...
one thing. I'll continue with the urgent motions today. You bring your other side so that necessary order can be passed. Right?
No.
And in case it is not taken up prior to rising, please mention with your other side.
My lord, much.
Where is your other side?
Yesterday they took time.
Yes, and today nobody is there.
Sukanta Chakraborty. I have
Today-
served notice. Today morning I had a talk with Mr. Chakraborty. He said that he will come.
Yes, then what happened?
This notice was
This is very unfortunate, you know, if the... Did you serve the office at 11 Strand Road?
generally it is DGFT, my lord, they don't accept because this.
Oh, they don't accept. This
They
is the
don't accept
reason.
because of the department is different.
What is to be done? What is your prayer?
Prayer is, my lord, may I just remind you, lordship, my lord, there was a focus product scheme introduced in 2009, my lord, foreign trade policy, under which, my lord, if any exporter exports technical textiles, my lord, of filament other than cotton, my lord, they were entitled to 2% of FOB value. My lord, this was going on. Now, this policy was amended on 21st October 2011 by limiting this my lord, term textile to 33 items, specific 33 items. But prior to that, my lord, they were allowing that all type of technical textile for 2% this my lord, benefit. Now, they, my lord, after the amendment, they tried to give effect of that amendment with my lord, retrospective date from 1st April. My lord, that, now after that, my lord, in case where the already they paid the benefits, my lord, they asked for recovery. And in my cases, my lord, my applications which were there, my lord, prior to 21st October 2011, those were not considered. Citing this, my lord, amendment. Now, in one of my sister concerns came before this honorable court. Well, they challenged this retrospective effect of the circular. The single judge of this honorable court held that it cannot be given effect to relying on the decision of the honorable Supreme Court. Well, after that, we made representation that you should follow when you have given to my sister concerns. As per the judgment of this honorable court, you should also give the same benefits to us. But they didn't do. Then the matter was referred to a policy relaxations committee of the Directorate of Foreign Trade. They gave decisions. Kindly take page 63. It starts from page 60. After a long. Our case was case number 94. Page 63 is the first decision. Case number 94. Now they narrates the facts from a decision. The committee went through the statements made by the firm and noted that the applicant has not submitted a cogent reason justification in support of any genuine hardship faced by them. There's no question.
I'm led by Advocate Sukanta Chakraborty. He's into his legs. He's coming, just praying for a short Passover.
Passover will not be granted and today the matter will be decided. Just let him know because every day it is being adjourned on his ground.
He's coming.
Please let him know.
Kindly take, I don't find any reasons, what is the basis of citing genuine hardship faced by them. Then it was reviewed. The next decision came, page 73 it starts. The relevant portion is, page 64 it starts. Relevant portion is 67.
Yes.
The committee heard and reviewed the case on the basis of justification furnished by the firm along with report received from RA Kolkata. After detailed discussion, it observed that there is no merit in the firm's contention, hence it is decided to maintain rejection of the earlier decisions. Now I'll show the first the policy. Kindly take page 24. It's part of foreign trade policy of 2009 to 14. 24, focus product scheme, my lord, the bottom 3.15. As you last got it. Now kindly take 3.15.2. Exports of notified products as in Appendix 37D to all countries, including SEZ units, shall be entitled for duty credit scrip equivalent to 2% of FOB value of exports in free foreign exchange for export made from 27th August 2009 onwards. Now these was there was no classifications. All item, all technical textiles coming under this Appendix 37D of the policy was allowed. Now this was amended. Kindly take the amendment at page 29.
Yes.
First line, is dated 21st October 2011. Serial number 33, table 4 of Appendix 37D of HPV 1 allows FPS benefit to products covered under ITCHS code 5407 with descriptions technical textiles. Now this is tariff code, customs tariff, describes various products. Woven fabrics of synthetic filament yarn. Reference have been received from the regional authorities seeking clarification on coverage of the products classified under ITCHS code 5407 for FPS benefit. The matter has been examined. It is decided that a technical textile is a textile product manufactured for non-aesthetic purposes. Her function is the primary criteria. Technical textiles include textiles for automotive applications, medical textiles, geotextiles, agro-textiles, and protective clothing like heat and radiation protections for firefighter clothing, molten metal protections for welders, such and such. Accordingly, only 33 items as listed in the annexures are covered under technical textiles. Now, these annexures you will also get from the bottom. Now, these was kindly take effect of this circular on the same page. Only 33 items are eligible to get FPS benefit under the heading technical as per serial number 33 of table 4 of such and such. The list of 33 so eligible is in annexures to this policy, and this list is applicable for exports made with effect from 1st April 2011. That is a 6 months period, and it's huge because during 6 months many exports were made and they were entitled to get this 2% benefit because it can only be prospective. I'll be citing 2 decisions of the Supreme Court also. Now, this matter came up before this Honorable Court. Kindly take page 39.
Yes.
At that time also I appeared along with Mr. Bhaskarshan. I'm just giving on the same facts, same issue. Kindly straightway come to 41.
Yes.
Last but one paragraph. For those reasons, these writ petitions are allowed to the extent that respondent authorities are restrained by an order of injunction from denying any duty benefit to the writ petitioners earned by virtue of exports of goods understood by the parties as technical textile before 21st October 2011. The notices issued by the department to deny benefit to the writ petitioners and making a demand for reversal of the duty benefit are without any effect for exports before 21st October 2011. But I make it clear that the respondent authority will be free to proceed in accordance with the said policy circular with regard to the exports on and from 21st October 2011. So this retrospective effect of that notice was held to be not applicable. The observations you also will kindly take 41. Just,
are you ready with
second paragraph.
instructions?
My lord, I am ready with instruction, but my lord, only one thing. My lord, with regard to my lord, the foreign trade policy, my lord, they have annexed, my lord, at page 23. My lord,
Yes.
doesn't contain, my lord, all the, my lord, paragraphs, because they have, my lord, pick and choose, they have annexed. If your lordship kindly comes to page 23 and 24 for a moment,
my lord, the entire policy I need to, my lord, place before your lordship, because my lord, the hardship ground which my learned senior friend is taking, my lord, that is, my lord, at the discretion of the government. My lord, I will place, my lord, 2.58 of the, my lord, FTP, which my learned senior friend has annexed. My lord, that has not been, my lord, the entirety, it has not been annexed. My lord, may I just come back, my lord, on the very
My
next
lord, I
page,
have
my lord,
got
annex.
the, my lord, policy, my lord, of that period, my lord. Obviously, it includes
Because
the
my lord,
amendment.
this particular period, my lord, which my learned friend is claiming, my lord, benefit, my lord, although, my lord, I must be candid to your lordship, my lord, the judgment which my learned senior friend is relying on, passed by Justice IBM Kochi, my lord, I have, my lord, also, my lord, come across, my lord, two judgments of, my lord, of this Honorable High Court. It is going against me, but my lord, the argument which I want to advance, probably that has not been raised, my lord, there. So, my lord, if your lordship kindly, my lord, grant me, my lord, one accommodation, my lord, I will come back with the entire
See,
policy.
the accommodations, not one, repeated accommodations have been granted
That is
on
why,
your ground.
my lord, I
So you should have been ready.
my lord, I am ready, but my lord, the entire policy has not been annexed here.
You could have got it. It is your policy.
My lord, my lord, may I just, my lord, place, my lord, then.
Now, before that, my lord, I is also relying on the two Supreme Court judgments. My lord, kindly take, my lord, 2006-13 SCC, page 542. It was also referred to in that judgment. My lord, kindly take paragraph. नहीं তুই বলছিস কোথা থেকে পাচ্ছিস
Paragraph.
My lord, kindly take paragraph 48. My lord.
The judgment comes from place control.
2006-13 SCC 542.
Asian
food. The same prohibition was imposed with retrospective effect in that case also. It was held that it can only be made prospective.
Yes.
Now, second judgment, my lord, was subsequently also affirmed by the Supreme Court in 2016, volume 2 SCC, page 542, page 226.
2016, volume?
Volume 2, SCC, page 226. But kindly take, my lord, paragraph 113 of that, my lord, judgment.
Yes.
Paragraph 13 of that judgment.
113.
113, sorry.
Yes. It's a big paragraph.
Not big, my lord. It says that the government had the power, my lord, to amend any policy, but it cannot be given retrospective effect. That was exactly what has been held by the Honorable Supreme Court.
Yes, central government to amend the policy.
113, my lord.
That the provision empowers the government to do it retrospectively.
There are other paragraphs, my lord. It was entirely discussed, my lord, from paragraph 105, 109, and 110. Then the relevant portion is 113. All judgments have also been referred to in that judgment. This policy has been made under Section 5 of Foreign Trade Development and Regulations Act. That is the power of the central government.
What is the hardship issue that your learned friend is mentioning?
There's no such. Nothing in the. I have got the entire policy with
Yes.
me. I have asked my learned friend.
Where is this
Because there is no
hardship.
question. This is my entitlement. I need not show hardship because
Right.
they denied my benefit. They did not give me the benefit which I am entitled to. No question of my showing any hardship that because of
This reason.
because I didn't get this benefit, I suffered hardship. Malad, this is absurd. Malad, when under law, malad, on a promise, because they are bound by the promissory estoppel, because they promised to give me malad 2% of FOB value. Now, subsequently, they are well within their limit malad to withdraw such promise. But that cannot be malad given a retrospective effect. But it is well settled, malad. There are other judgments of this honorable court also. Justice Indira Banerjee has held malad the same thing, which is also relied on.
Page 24, which you relied upon, this is 2% you are getting the FOB from 27th of August 2009 onwards.
Yes.
And what they are doing, they are curtailing it.
They are curtailing it on 21st of October 2011. They can do so, but it should operate from 21st of October 2011, not prior to that. And my applications which have been pending, those are related to the period which was prior to 21st October 2011. This is my simple case, which they could not have denied. Because I exported on the basis of the promise which was there in the export-import policy. Now suddenly they said, no, I am limiting it to these items. So you are not.
Lordship, may kindly have a look to page 4, paragraph 7, of the petition. The petitioner, is an exporter of, Lordship, kindly take note of this term, technical textile man-made synthetic filament yarn. My humble submission is that, he is claiming, the benefit as, serial number 33 under table 1, chapter 5407. This, what technical textile is in a broader sense, it has been, included so many things, but man-made synthetic filament yarn, doesn't.
See, you have to restrict your submission with regard to the rejection, which is at page 63. You cannot go into all these things.
Yes.
Then it only says, the decision says that the applicant has not submitted any cogent reason, justification in support of any genuine hardship.
Yes. Yes.
Was the petitioner at all bound to show any hardship to you? He was not. Show me that the policy requires hardship to be suffered.
Yes, for that 2.58 probably, if I'm not wrong, the entire policy, may I just come back, because hardship ground is there, I'll try to show it to your Lordship.
Please come. Achha. The benefit under the focus product scheme to the petitioner has been rejected on the ground that the petitioner did not submit any cogent reason / justification in support of any genuine hardship faced by them. Stop. The excerpts of the scheme are annexed to the writ petition. Stop. There is no provision for producing any document, reason / justification in support of the genuine hardship suffered by the applicant. Stop. The scheme has set out certain benefits which the petitioner claims. Which the petitioner claims. Stop. The authority has rejected the claim of the petitioner, citing a ground which is not available in the scheme. Paragraph. The petitioner relies upon the decision of this court and also of the Honorable Supreme Court in support of the submission that the authority could not have relied upon the said ground for rejecting its claim. Paragraph. Learned advocate representing the respondent authority submits that there is a provision to consider the hardship faced by the applicant. Stop. Time has been sought to produce the relevant provision before the court. Stop. When can you come back?
Well, sometime in next week.
Sometime means when? This is pending for quite some time.
Lordship kindly keeps it on Friday.
Friday?
This Friday.
Day after tomorrow?
Day after tomorrow.
Day after tomorrow will be too early for you. That will be too early. That I can understand. Next Wednesday, I am keeping it.
Well,
List on 29th. Stop. Learned advocate representing the respondents shall produce the relevant provision of this scheme relating to hardship.
My lord, one more thing, my lord, subject to your lordship's kind, my lord, sanction, my lord. I want to change the maintainability of the writ petition also, because this is an order, my lord, passed by a quasi-judicial authority, my lord. My lord, entertaining writ petition, my lord, challenging an order of quasi-judicial nature, my lord, is very limited. My lord, after my lord, this Honorable Supreme Court has come up with the judgment of Ayurvedic sciences, my lord. It is, my lord, my humble submission is not maintainable unless and until there is a jurisdictional error.
Very well. If it is not maintainable, then is there any appellate forum?
Yes.
What is the remedy available to the petitioner?
My lord, they have probably, my lord, if I am not wrong, they have probably availed, my lord, the remedy of review.
After the order has been passed by the review committee, where does the party go?
Yes, my lord, 227, my lord, is available. My lord, in case, my lord, in case there is no remedy.
I am not recording anything.
My lord, I'll argue on that also. Ayurvedic science বলে দিয়েছে
হ্যাঁ দাও
আবার কি স্টেপলার নেই স্টেপলার নেই একটা
Yes.
The tender matter, madam. The condition of tender as such, I made a representation to clarify the situation. Nothing more. That your lordship will get at page 126. Always hearing the main matter. So, not for interim order. Interim order is there. Kindly come to 126.
What is the clarification that you are seeking?
Yes, that I will show to your lordship from here. In the event there is a tie.
126. 126 is a letter of yours.
Yes, yes. That my representation asking for clarification to them. That was not adhered to. I move your lordship's call. Your lordship court passed a direction to consider my case and to pass an order in consonance with the representation. Before that, my lord, it is my friend is correct. I must show to your lordship what is the deficiency we am asking for.
119.
119. Kindly come to 119.
Yes.
This is the notification of which we are asking for a clarification. Kindly come to 121. After the tender is floated, my lord, if the tie is there, result comes out tie. What is the situation then? Kindly come to situation III in case of bid. Has my lord come up?
Yes.
In addition to what has been stated in situation 1 and 2 above, the following procedure should be adopted when there is a tie among L1 bidders. Keeping the discovered L1 rate as ceiling, sealed bids may be invited from all the L1 bidders, and out of those, the lowest one may be selected. If one of the L1 bidders is ready to offer further reduction of rates, A, for items divisible in nature, the work may be distributed equally among the contesting L1 bidders. If none of the L1 bidders is ready and to accept reduction of quality, the bids with the higher credential has to be accepted. There are three eventualities. So to come to third, its language is clear. If none of the above is adhered to, then they can approach third. But what in fact and reality what is being done, after the tie, this credential, but third eventualities has been accepted. This is our case made out.
Third eventuality means
the higher credential. Credential is first of all judged at the initial stage. At the stage of my lord, considering the bid, whether a commercial bid will go or technical bid. So it has been considered. I was eligible, participated. 3 L1 rate given. For to resolve that, these are the criteria laid down. We have challenged that. Now kindly come to my representation.
Did they consider?
Not in consonance with the statement made in the representation. What they say you are not given any instance. So I don't know what will happen. Well, it should be prior to that. If it has happened, goes. But now, my lord, kindly come to page 131. Oh no, before that, my lord, kindly come to 126. At verse 27. This is the clarification we sought for. 127. As per memorandum, it is stated in situation 3 in case of bid as follows. In view of the above mentioned circumstances, I seeking the following clarification. What is the clarification? Whether the guideline for acceptance of tender as per the memorandum of such and such shall be followed in case of tie bid.
What is what is there in 2320?
That I have shown to Lordship, that is now.
Okay.
That circular. After opening the financial bid, if the discovered L1 quoted rate of the administrative charges is found 0% on and above the cost of raw materials, and the said bid become in tie situation, then whether further sale bid shall be invited from all the L1 bidders, keeping the discovered L1 rate as ceiling, and out of those, the lowest one shall be selected, following the guidelines framed in situation 3 in case of tie bid. After coming the financial bid, if the discovered L1 quoted rate of the administrative charges is found 0% on and above the cost of raw materials and the said bid become in the situation, then can I as a bidder be permitted to quote further reduction of rate below the rate of cost of raw materials in terms of that notification. This was the specific queries made. The order passed by your lordship's court, my lord, kindly come to 131. Nothing more to be looked into. First paragraph, it says, by directing the authority concerned to clarify the queries of the petitioner made in the said representation. As my lord's 131.
Yes, yes.
There is
Then
nothing more to look.
139 is the order.
Yes. Oh, my lord has reached there.
Yes.
অর্ডারে বলেছিল বসিরহাট ফুড সাপ্লাই মহিলা কোঅপারেটিভে যে অর্ডারটা সেই অনুযায়ী তোর এফিডেভিট দেওয়ার কথা রিপোর্টটা এই হচ্ছে মহিলা সম্পদ সাপ্লাই ডিভিশন বেঞ্চ
Oh yes, I should, my lord, show to your lordship, my lord, division bench order in this respect. That is at page
15 of my exception.
Well, kindly take my exception
Page 15.
or reply.
এর বেসিসে
Before that,
এর বেসিসে এটা দিতে বলেছিল
yes, my lord, kindly come to page 15.
আচ্ছা বলেছিল এর বেসিসে রিপোর্টটা দিতে
Page
15 of the my exception. It starts from page 11.
Yes.
এই সব করেছে
This is another matter, but point was same. My lord, it will be travel to the entire order. Kindly come to 15. The penultimate paragraph of the division bench. In the affidavits to be filed as per the direction of the Honorable Single Bench, the state respondent shall categorically state how situation 3 had been followed in case of tenders floated subsequent to the memorandum dated 7 June 2022 in case of tie bids amongst L1 bidders. Special mention as to whether the amount quoted by the L1 bidders has been kept as the base and whether the L1 bidders were asked once again to offer their competitive rates must be stated. The observation are privacy. On the basis of this, my lord, your lordship passed an order on 19th November 2024 in this matter. Your lordship direction was to file an affidavit or exception in tune with the division bench order. Now, my lord, I will come to that later. Now, kindly see the order impugned. Kindly come to 130. Narration of facts. Then, thereafter, the undersigned has gone through all the available relevant records. in the matter and come to the following findings. Kindly read this, keeping in mind the order of the division bench and my queries. In supersession of all the orders published earlier for tender procedure, the Finance Department, by dint of memo number 2320, laid down norms and guidelines.
Serial number 7 is important, possibly.
My lord,
139. The authorities cannot run with you. You are thinking of an hypothetical situation which the authorities are yet to comprehend.
That is my specific query.
This is what the authority is failing to understand.
It's my fault. My lord understand. Director, they do. I can do.
Yes.
You have to thought. You have to think that you are putting a condition.
Situation arises.
If the put, that is my clarification. What I will do in that situation. So if it is clarified, I will quote accordingly. There may be situation I may not reduce much, or maybe situation I now quote high, then I will reduce it. So the tenderer should tender.
The strategy which the tenderer will adopt will depend upon their clarification.
Right. If they say that this will happen in case of this, that is the query. If the query is answered to me, I can plan accordingly. And that's the understanding of the division bench and my lords also. So this is the my lord has read that.
141 instance decision.
No, 139, please.
Yes, my lord, kindly see. This is the two. First of all, let it be abundantly clear that the existing norms has to be imperatively followed by the state government department and is undertaking local body such and such, such and such.
Whenever
while conducting their tender, there is no question of deviation from next. Furthermore, it reveals that whatever points arguments have been raised by the petitioner in the present writ application, as these contents are completely based on apprehension and surmise drawn by the petitioner himself. The petitioner has not produced any supportive document during the course of hearing, wherefrom it can be deduced that the corresponding provisions in memo number has been violated. I have not said violated. This is a misunderstanding of the order of this our representation and the order of the court. This is the order. Now, my lord, kindly come to
141.
141. Kindly come to one example has been given.
Yes.
In reference to NIT such and such, bidder namely as follows.
L1 bidders.
These are two L1 bidders.
Two L1 bidders, a
What will
tie
happen?
bid.
What will happen?
What will happen?
This is our query.
Yes.
Then, my lord, in reference to such and such, what they did, it is to third.
They?
Third eventualities.
All right.
First, second has not been adhered to. Particularly when third said, if 1 and 2 is not matched, you can
then
come.
only come to 3.
Now let us see, my lord, they are affidavit in opposition.
120.
Same report, identical.
But they cannot improve much in their opposition.
Whatever is there, my lord, I cannot.
121, 127.
Then why you prayed for?
No, I have not paid for. I have. If the situation is not arises, my lord, how I, my lord?
Thing is, they need planning. Your department is not so well planned, but they require planning for putting in their bids.
Lordship.
It is their business.
My lord.
You are the government. You are not concerned, but they are concerned about their own finances.
Lordship. But
do you understand what is
I
their
fallen from his lordship?
yes.
Now the problem is, my lord, that division bench order is staring at our face.
What
In
division bench?
each and every tender process, my lord, in our exception, in our report, my lord will kindly take this second paragraph, my lord. Kindly take second paragraph once, my lord. In this connection, I'm sorry. In second page 3, lordship will kindly see. In this connection, it may be submitted that memo dated 2320 so and so issued by the Finance Department, Government of West Bengal.
This is what is dated. It's the same thing.
It's the same thing, and not only that, there is a stay order of Honorable High Court Kolkata in connection with the NIT floated by the tenderer by the healthcare facilities in the 2022. Tender
That has
process is
got
stayed.
nothing to do with the clarification. The petitioner is not seeking stay. He is not seeking the vacation of the stay order either.
No, that is a separate matter. That nothing to do with this matter.
And in paragraph 4, kindly takes paragraph 4 once, my lord. It may be further submitted that there is no mention by the petitioner in WPS 1, so mentioning the specific e-tender number as to whether
all that this is the condition.
Your clients are going just nowhere near the clarification that has been
they have
sought.
sought for. Because, my lord, the problem is, my lord, what has fallen from his lordship is the situation. If the situation arises, my lord,
They
then
cannot
but there should be,
apprehend.
but
They cannot
but
apprehend.
No,
there
no,
should
I
be
beg to
There
differ.
should be something.
something
beg
in
to
the,
differ.
if it is tied, then
I
it should
beg
be
to
that
differ.
should be the tender clause.
Right.
But I beg
That
to
should be
differ.
the tender clause.
I have shown to you page 141.
And 141 is a
But this is the eventuality.
out of 100, my lord, one has been but so far
No, suppose the 141 is there in front of you, what will you do?
that, my lord, they have they have already done something, my lord,
Done,
but
which
that
is
has,
legal.
that
Jump
is
to
right.
third. Jump to third clause. Can you see
No,
this?
1 and 2 is there. Third clause is the third clause is the main problem as such. So hence the situation 3 memo dated issued by the Finance Department West Bengal is applicable for any tender floated subsequent to issue of the Finance Department. Now, my lord, this clause 3 is related to tender.
Page 121. Let us read it together. If your authority cannot do it, then the court has to
Lordship.
find out something.
My lord.
So that it can come to your aid also.
Yes, my lord.
In case of tie bid. Read out, Mr. Basu. Please read out. I can hear. This is the difficulty. I can hear what you are whispering.
I am not. I'm just got nothing else.
Whatever. I can hear it.
Stop.
Please read out 121,
My lord.
page 20. In case of tie bid, yes.
My lord, I will.
So that Mr. Basavalli can understand.
I will place before lordship third first.
All right.
My own humble way, kindly allow me to place the third plus. A1 II. If none of the L1 bidders is ready to accept reduce of quantity, the bidder with higher credential based on the following primary may be selected. Meaning thereby, if 1 and 2 is not fulfilled, then only third will come. Am I clear to my lord?
It is clear to me. It has to be clear to the authority.
It is my lord's duty.
I followed, my lord. But that clause, if that be there, my lord, this situation will not. If such situation arises, my lord, then this will be followed. That there should be. I followed.
Thing is, they will submit the bid. They'll fix up their own strategy to submit the bill. You go by whatever is there because that is your stand.
Lordship.
So in that case, you have to follow 1.
My lord.
Thereafter 2.
Then 2 and then
not
the
available,
not available, then 3. Lordship. I follow.
So first is keeping the discovered L1 rate as the ceiling. What is the L1 rate? That is the bid. That is the tie rate that has come up.
Yes.
That should be kept as the ceiling, and then sealed bids may be invited from all the bidders, and out of those, the lowest one may be selected. So that is the ceiling. Fresh bid out of these, and then whoever comes with the lowest gets a chance. This is the first one. If none is ready to offer reduced rates, suppose no one is willing to reduce the rate, then what happens? For divisible items and for the non-divisible items, A and B is separate.
Lordship.
The work has to be distributed equally among the consenting L1 bidders. Suppose it may be that no one consents, or at least one consent, one does not. If the person who consent will get it. If there are 2 persons, more than one who consent,
segregate.
Distributed equally.
Equally, Lordship.
Segregation, not proportionate segregation. 50-50
means you give 50-50.
50-50.
If it is time bound, then if it's 3 years, 1.5 and 1.5.
If none of the L1 bidders is ready to accept the reduced quantity, the bidder with the higher credentials based on the following parameters is 1, 2, 3 comes in.
Lordship.
May be selected.
Yes.
You follow this. This is your stand.
Yes.
Now, another thing may I show to you.
Yes.
Kindly come to page 32 of the exception.
32
of the exception. Similar situation cropped up. I will not travel over the first paragraph, second paragraph. After successful evaluation of the financial bids of all the technical qualified bidders, it has been observed that every successful bidders has quoted same rate in their respective BU. Then what they did?
Tie bid.
In these circumstances, kindly next paragraph.
Yes.
As in the tender committee, the tender information authority, the process of draw of lots.
This is not there.
That's been done.
This is
Not
contrary
there.
to this.
Now the question to my learned friends policy is that when this system which was prevailing, why this has not been accepted to make it so complicated? I know I cannot challenge policies unless it's arbitrary. I want to show to you this decision, this 1, 2, 3 is arbitrary and unworkable in some cases. Then
Draw
this
of
draw
lots is better.
much better. It was prevailing there. Depend upon luck, like me. There are
No, just the opposite.
I did not say good or bad, I say luck. So this, I repeat, this power.
No, but then what is your prayer? Clarification is something else. But if you say that draw of lots has to be then that's different.
No, I am saying both. If it is clarified and I am submitting my lord, if something to be achieved, the politician has to achieve something. What is achieving here? What they are achieving here by this process? Make it more complicated.
Litigations.
Yes.
But since when I started profession here, I am doing these cases. Since 1987, this diet matter is going on.
The more it goes on, the better for the bar.
New chapter opens, new things comes, and matter will be filed.
Make it more complicated so that.
But so far page 120
now it is up to my
is
lord.
very clear. Page 121, if
Now,
in
my
the
lord,
tender process, if it is mentioned,
up
my
to
lord,
your
that
my lord.
121, if tie bid situation arose, this will be followed.
No, but see, tell me one thing.
My lord.
Apart from these financial rules which are there in place, in each and every tender, there must be a clause as to how the tie bids are to be
No,
dealt with.
that has shown to your lordship. That
It
is
is not there. In
120
individual tenders.
121. That is 121.
No, this is in place.
This is in tender wise.
This is.
My lord, no, this is a notification. This is for all tender.
Yes, it is in
clause
general.
Inserted.
This is in general, it is prevailing. But when they come up with the individual tender notices, then there are clauses, isn't it?
That page 31, in that tender, they have not followed this. They have accepted draw of lots.
You are not
Parties are
prejudiced.
accepted, my lord.
You are not prejudiced in any manner.
Yes.
No, I cannot plan. If that clause is there and eventualities are there, then they cannot jump to third unless 1 and 2 is complied with.
Till the tie bid, you do not plan.
No.
Till the tie bid, you
I
cannot
have
plan.
to keep in my mind that that may be tie.
Certainly.
So, I have to quote on that basis.
Yes.
If it is not clarified to me what will happen in these eventualities, then I cannot plan. My lord is rightly observing. That's my prejudice.
No, but then till the tie is there.
Yes.
What can you plan?
No, I repeat, I have to answer this that there may be tie.
If it is a tie, if the draw of lots is there, it's fine.
It's fine.
And if they do not have anything
then
special,
I am getting another chance.
Another chance in terms of this.
In terms of this, madam.
That I'm saying. They are not offering. I have shown to your lordship, page 131, straightway jumping to third without compelling in 1 and 2.
No, that I can clarify. Please
that's
come.
why I prayed for a clarification.
The petitioner is aggrieved. By the reasoned order. Passed by the Additional Chief Secretary, Government of West Bengal. Finance Department. Allegedly passed. on the prayer seeking clarification of the
সরকারি মামলা যা পাপ ছিল আপনার তো খরচ করছে
comprehensive procedure and guidelines for acceptance of bids under different situations published by the Finance Department. Vide Memorandum number 2320-F within bracket caps Y, dated 7th June 2022. Stop. Paragraph. The petitioner wants a clarification in case of a tie bid. Stop. The petitioner alleges that the petitioner submits that according to the aforesaid memorandum, there are 3 stages as to how the bid is to be accepted when there is a tie amongst the L1 bidders. Stop. The petitioner alleges that the authority at times, are not following these steps as mentioned in the subject memorandum, but are directly jumping to the last step. Stop. It has also been brought to the notice of the court that on occasions, the authorities are selecting the bidders upon draw of lots, which is not mentioned in the subject memorandum. Stop. Next. The reasoned order impugned herein mentions that the existing norms of the subject memorandum has to be imperatively followed by all the government departments and its undertakings, and there is no question of deviation of norms as envisaged therein. Stop. Paragraph. The said authority in the absence of a particular situation or example, was not in a position to render proper clarification sought for by the petitioner. Stop. Paragraph. In the exception that has been filed by the petitioner to the report filed by the authority, the petitioner has annexed a copy of the decision of the tender committee and the tender inviting authority of the Chief Medical Officer of Health, Bishnupur Health District, being memo number CMOH/BHD/225, dated 1st February 2023, wherein two successful bidders were found to have quoted the same rates. Stop. The committee decided to proceed with the matter by draw of lots. Stop paragraph. The petitioner alleges that the same could not have been done as the procedure of selecting bidders through draw of lots is not permissible in terms of the subject memorandum that is prevailing. Stop paragraph. Upon hearing the submission made on behalf of the parties and on perusal of the documents placed before the court, it appears that the Chief Secretary, in principle, has opined that the existing norms of the subject memorandum has to be followed imperatively. That being the stand of the government, all the authorities under the government who will be floating tenders in future will be liable to take steps in terms of the subject memorandum and not otherwise. With the above observation, the writ petition stands disposed of.
Yes, is it also pleasure to mention page 141? They have done that. I have given instance.
But my lord, in this matter, my lord, so far this matter is concerned, there is no specific that I have stated in my report.
I have mentioned the draw of lots.
Yes.
Draw of lots, and also, my lord, my grievance is that it cannot go third without complying 1-2. That I have instance I have given.
The authorities shall strictly maintain the stages which are to be followed in terms followed in a tie bid as indicated in the subject memorandum.
My lord will not be mentioning that one instance I am giving that is having done. 141.
That is not the challenge, my lord.
No, not challenge. I
Maybe
said that
since
but the lordship has mentioned in the order.
I have made it more or less clear that they will follow the stages.
And my lord also mentioned the draw of lots.
Draw of lots.
That is mentioned.
And prevails. That will be done.
Grateful.
Otherwise, poor judges will be sitting here to decide these things. Absolutely poor.
My lord, I
Time. Poor because of time.
These answer, my lord, cannot be given in court.
Two held up these. Yes.
My lord, what is about these COVID barriers?
It can reopen this. Now COVID is no more.
Something else is coming.
No.
That is normal.
No. That is,
that is normal.
That is the medical authorities. Nothing else. This is for business. Nothing is coming.
Yes. 28.
Very short point involved. There is a matter to have connection by the wife.
I appear on behalf of the respondent number 4, Milord.
Allowing her. So the last date, Milord, was pleased to direct you. She is entitled to make application through online mode, and we have to ensure Milord or inform whether she has made or not. Yes.
Has it been made? Has it been made and has it been accepted?
No, my information goes, Milord, yesterday through WhatsApp, not yet made.
Yes, my lord, we have made.
When?
Show it to your learned senior friend.
Milord, only one thing, Milord, against that order, Milord, the respondent number 4 has preferred an appeal, Milord, that is pending.
And then stay order has been granted. Get a stay.
Lord, we have decided,
Just
Milord,
stay.
my lord's view is upheld. We are willing to give connection. that will not create any equity or any right in
No,
any
no, that
manner.
is mentioned. Possibly I'll
Yes,
mention
yes,
it
that
also
is
if
there,
it is
but-
not mentioned.
But my officers are yet to receive any application either on online mode.
Give a copy, give a copy. When was it made?
Where is
The
it?
date or time is not written here.
How will the authority get to know?
You have to
Is
fill up
there
the
any
form.
mention that it has been submitted, accepted? What it is
Prescribed format.
mentioned?
Prescribed format it has been submitted. Has it done, have you done this?
He has done, but the time
How?
and date is not mentioned here, my lord.
Where from I shall get it that you have done this?
Lord, till the
My lord, here is nothing of this sort. You have to know your estimated quotation, passport size photograph. This is the information. My information yet to receive.
Please come.
my lord, only thing, my lord,
Video order dated 8th January 2025.
কোথায় অ্যাপ্লিকেশন তো রিসিট আনবে তো তো আনো না কেন সেটা
The petitioner was
বললে হবে না
permitted to file online application for obtaining new electricity connection. Stop. Paragraph. There is nothing on record to suggest that such an application has been made. Stop. The petitioner shall take steps in accordance with law.
Lord, kindly, my lord, records that the respond number 4 has preferred an appeal, my lord. This is the status.
Keep it with you. What will I do by keeping the status? Go and mention it before the division bench. Get the order set aside, cancelled, modified, whatever you feel like doing.
আইটেম কত এটা 28
আচ্ছা, adjourn করে দিন তো। Adjourn, let the writ petition appear in the list for further consideration on 12th of February.
My lord, kindly let it come to an end. If they make
But
an
only
application,
one thing, my
all
lord,
right. If
my
it
lord,
doesn't,
only
my lord,
one thing, if the my lord, the petitioner makes an application and the electricity is given to that premises, my lord, my appeal will become infructuous. My appeal
That
will
is the more the reason to go and obtain a stay. Yes, call.
So, my lord, 12th February, lordship.
Item 29, I beg to appear through virtual mode.
May it please, Your Lordship, I'm appearing for the petitioner, my lord, in the matter.
Mr. Arjit Chakravarti is appearing online, my lord.
I beg to
Bunch of
appear
matters,
through
my lord, from
virtual matter. My lord, on the
29
last
to 36. But kindly take up item number 30, my lord, as a, it's the same facts, my lord.
How long will you take? Likely to take?
It'll take some time, my lord.
It'll take some time.
Lordship, I am appearing for the
Very
Union of
interesting.
India.
May I take a preliminary objection with this, my lord, affidavit, which has been served on us. There are annexures mentioned. Annexures are not given to us.
Yesterday we have served, my lord.
Yesterday.
My lord, let me make the submission. my
But
lord.
may I also file
In
the
this
reply?
regard.
We'll argue the matter. My lord, it's a
My
very
lord,
short
the-
point. Section 5 of the Act, my lord, states
lord, with
attachment
respect
for
to the-
180 days. All that we are praying for, my lord, is 180 days is long gone. 2022, they have never disclosed this in the affidavit that the proceeding was in 2022 when they attached. That's on record. My lord, 180 days have gone by. My lord, what they do now is they, my lord, have a subsequent search in the same premises. And my lord, upon learning, because we have been contending that 180 days are gone, statutory period is over, you have to detach this account. What they do is, my lord, they again conduct a search and they attach the same account. Now, the problem is, I'm carrying, my lord, judgments on the proposition. If the period is over, without passing a fresh order, giving fresh reasons on a fresh set of facts, you can't go ahead with a subsequent attachment. And another, my lord, line of argument that once the initial action was bad in law, all subsequent actions fall. That initial action was bad, I'll indicate that, my lord, from the facts. And there's complete suppression in the affidavit as well, because, my lord, this point has not been taken up. It will take some time, my lord, I'll indicate from the documents. May I file the reply since they filed the opposition?
Yes, Mr. Chakravarti, were you submitting something?
Yes, my lord. Just to reply to the preliminary objection raised by my learned brother opposite. My lord, his advocate on record was called by my advocate on record, even by myself, to hand over the entire set of report in the form of affidavit, since with annexure, it consists of not less than 127 pages. His advocate on record showed inability to collect it. So we emailed the report entirely.
Very well, all these, please do not enter into all these
So
things.
Mr. Bagh should have that much of information. I believe he has not been appraised with these facts. And
Mr.
my
Chakraborty, in that
junior-
case, I'm sorry. I'm sorry. I apologize to you. I
And-
did not know that. Anyways, we have it now. We can have it.
Yes.
We can argue the
Yes.
matter. I did not know of this.
Please come. And has only one affidavit been filed? In
It is
respect of
affidavit in
all?
the form of report.
It's
Report.
a report to which we have
Report
taken an
in
objection.
connection with all?
With
all
all,
the
these 8 matters, my lord, I would request your lordship, there are 2 other matters. My learned junior is carrying the details arising out of the same fact, which are in the list, but differently listed. So if your lordship can add those 2 matters also in this bunch.
That is different, but tell me, will one report suffice in respect of all?
This
They
8,
filed
yes.
one in respect of all, my lord. That's the
All.
pleading. That's the
Yes,
pleading.
yes. This one report for 8 matters.
8 matters.
The
I have
report
filed
in the
it in
form of affidavit
16904.
filed by the respondent numbers 2 to 4. And the reply thereto filed by the petitioners be taken on record. Stop. The matter is required to be heard. List for hearing on 7th of February 2025.
5th February, the appeal is before PMLA.
How does it matter?
Well, we
7th
have,
February
my lord,
2025.
my lord, there is only one information for your lordship's information, my lord. We have not dealt with the petition or any contention therein. Your lordship asked for the report, only factual report. We have made that much.
It's a
In the-
point of law, my lord. I
Point
don't
of
think
law.
point of law.
Factually, there is no dispute.
Factual they have dealt with. In the affidavit, they have given their facts.
We have given the entire fact. We have given the entire fact.
Then
As your
what
Nothing is
lordship
given.
asked
So
me on the
nothing.
last.
They only pray for one indulgence, my lord, since I'm told, my lord, the appeal is, my lord, listed on the 5th,
5th
my lord,
February,
Where?
before PMLA.
before, my lord, the tribunal. My lord, the
My lord, it
adjudication
should go
of
on.
tribunal.
This is
So, my lord,
My lord, it should go on.
proceeding is wrong.
Which tribunal?
PMLA.
my lord, PMLA tribunal in
Oh,
Delhi.
PMLA tribunal.
My lord, it is
All right.
ATFE, Appellate Tribunal for Foreign Exchange.
Even then, but then if it starts, let it start. The
Very
court
well. My
can
lord, we'll come back
decide
on the 7th. We'll come back.
Yes.
My
Come
lord,
back
these
on
2
this.
matters are also be tagged, my lord.
1 minute. 29, Pradeep. This order will go down in 29, 30, 31, 32, 33, 34, 35, 36.
Till 36. my lord.
Till 36.
Till 36.
My lord is keeping this matter on 7th.
7th of February. And what are the other 2 you say?
My lord, those are appearing in the monthly list, item number 1861 and 1862.
Are you there?
I'm not there.
No,
my
no,
lord. I'm
no,
not
they
there.
are
Then don't mention. Only till 36 the order is being passed. একটা রিপোর্টই তো ফাইল হয়েছে তাহলে কোন নাম্বারটা দিয়েছে দেখুন না 30টা দিয়েছে হ্যাঁ তাহলে ওটাতে লিখে দেবেন the report filed in WPA number 30 will be used in respect of the risk petition ঠিক আছে
Deeply obliged, my lord.
With your kind permissions, my lord, that matter 68.
Deeply obliged.
To mention this matter, and if it is not taken up seriously, my lord, I have served the notice to others. My lord, they are appearing also. My lord, yes, my lord, my lord,
other matters will not be taken up.
My lord, then may I mention item number 14, Mr. Bhattacharya, my lord, below the Bhattacharya, I have mentioned the matter. My lord, the interim order is expiring on Friday, my lord.
The other side is
Yes,
here.
my lord, I have Mr. Chakraborty, it is there, my lord.
40.
Item number 40, my lord.
What is the interim order?
Till, my lord, Friday. I'm just praying that, my lord, the interim order be extended till next Friday. And my lord, kindly keep the matter any day subject to, my lord, convenience on the next week, my lord.
Acha. Item number 40. The interim order that is subsisting is extended till Friday, till the 28th of February 2025 or until further order, whichever is earlier.
My lord, 28th is February, my lord.
February.
My lord, my lord.
And the matter will retain its position in the list.
Grateful, lordship.
No further matter, only the mentioned matter. Mr. Mukherjee. Which item?
well, I do 68.
68. All right.
Lord, I have served, my lord, to my lord,
But I appear from Lord the respondent of 5 and 6, the Chachol Bar Association.
I'm appearing
Lord,
for
I have
bar
a
counsel.
point about Lord the maintainability with reference to a division bench judgment. But I'm not shying away from the facts.
Maintainability of the writ petition against
directed against Lord an unregistered association of persons, the Bar Association.
Bar Association. All right.
And Lord, I'm not shying away from the facts even, Lord. If your Lordship hears me on facts even, Lord, I can satisfy. But
Without going into facts, just tell me, Is there any requirement for practicing as an advocate?
First of all, my lord, the petitioner's right to practice is never curtailed. I do not have any right.
Yes.
Do not have any right. But my lord, I can always regulate who
Yes,
becomes
that
my
you
member.
can. That
As
you
a,
can.
as a, my lord,
That
consider
you
my-
can do, certainly.
That is exactly, my lord, we have never
This is
said
the
that they are
thing.
not to practice. I cannot say that.
Your right to practice will not be
Well,
affected
that
in
is
any
it.
manner.
Lordship has protected also, my lord, in respect of the petitioners to, my lord, to practice and not to make any, my lord, obstruction in practicing. That is in what interim order.
order.
Interim order is there.
File
One
in.
that is, my lord, the 68.
68.
Well, that is
Yes.
up to, my lord, the 31st of January. Now, my lord, what happened? Your lordship kindly observe. Kindly on that day, your lordships recall this. The other 54 members, those your lordship's observation, they may have come. But the same situations was there in the respect of them. But those are also added. Trying to add, my lord, the application has been filed.
All of them.
No, my lord, the 4 has come.
4 has
And
come.
the, my lord, the one lady advocate is there. She is, my lord, apprehending even to return the, my lord, native place for outraging his, my lord, modesty. My lord,
No,
she is
this
not
is
the
not-
case.
this
Your
is
lordship
the-
and
Lord,
lord,
this is- Lord, I tell
What
you,
is
lordship,
the issue?
all the bar members are
and,
here.
yeah, no,
Lord, we have heard this, my lord. My learned friend is submitting before your lordship. We got, my lord, the recorded, my lord, that his submission. But this is absolutely untrue. And
What
this
is
made
happening?
only-
This should not happen.
Well, this is not happening at all.
Your
He
lordship.
is trying to say this just to impress my lord about, my lord, the urgency of the matter. We don't have any, my lord, right to do that. We do not have any inclination to do that. We don't have any propensity to do that. Why my learned friend, my lord, makes this submission, I fail to understand.
My lord, I need not have to, my lord, I must, my lord, I need not have to, my lord, trouble your lordship.
Your
If a
lordship is
lady
going
come,
on
my lord,
back.
from Chachol,
Oh, yeah, wait,
if a
wait,
lady
wait,
come
wait,
from
wait.
Chachol, and my lord,
Wait,
these recordings, your lordship,
wait,
I
wait,
have
wait.
had the recordings, my
Please
lord.
wait. Please wait.
But
Mr.
the
Mukherjee,
secretary of the
please
Bar
use your good
Association,
office.
but the words he's when he is
All
giving.
right, please wait. Please use your good office to resolve the issue
I'll tell you,
between the bar members. Do not let the court enter into all these things.
But I
See if
understand,
it
but
can
my
be
learned
resolved.
friend comes and makes an allegation.
All right,
which is
forget that the
absolutely
allegation has been made. What can be done to resolve the issue?
Lord, all that I say is that, Lord, we have taken certain action against, Lord, some members. They do not have any right to, Lord, seek a, Lord, a redressal before your lordship in a writ jurisdiction. If they are at all aggrieved, they have a different recourse in law. Secondly, Lord, we are not hampering their practice at all because we cannot do so. Therefore, Lord, without, Lord, the assistance of the bar.
No, but then the your document that was placed before the court.
Yes, my lord, that they have asked for my lord, for inspections
Page
and all these things. Whether the
56. Page
after even my lord
56.
membership.
1 minute. 1 minute. Page 56. What the Bar Association is doing, the Bar Association is finding out discrepancy in the educational certificate, admit card, mark sheet,
That is
registration.
so far as my members are concerned. I have got, my lord, 2 certificates. Your lordship will kindly have a look at it. On the basis of this, people are becoming my member. When I ask them that you come and show the certificates.
Which certificate?
Lord, the certificate of education. Lord,
Why will you ask?
Because, Lord, I have a right to see the qualified members are my members.
You have a right to see whether the person is registered with the Bar Council.
Lord, on the basis of, Lord, a fake certificate, if
you intimate to the Bar Council that your enrollment which has been granted registration is based upon false.
They're already done. Already done.
Follow it up with the Bar Council. But then in this manner, if you say that this is fake,
all that what
you
we
cannot
are
do
doing
this.
here, Lord, we have already intimated to the Bar Council.
It is for the Bar Council
Now,
to
Lord,
take
we
steps.
do not want this particular person, Lord, to be my member of the association. That is exactly what we have done.
Say that a document is false. You are a bar association. The court is not entering into merits.
Lordship.
Just a discussion.
Lordship, my lord.
How can the bar association have the expertise to decide as to whether a document is fake or original?
That is one aspect. We have given a pro forma. The gentleman before your lordship, Lord, he has in that particular pro forma which I gave, did not, Lord, give at the time even for my membership induction. Thereafter, that there are at least 4 cases against him, 7 cases against him. The form is blank. Blank. It are there.
Criminal cases. All right.
And not this, if this not persons
That
are
is
my
something
members,
different.
that is
a criminal case. It's different. But then the educational certificate,
that
admit
is
card, mark
another
sheet.
aspect of the matter. I'll come one by one. This was not the form that we have asked everybody to submit. Other members without any demo submitted. They also submitted, but the form that they have submitted is incomplete.
All right. This
No,
is in respect of one particular member.
the petitioner. The petitioner before your
One
lordship I'm
petitioner.
talking about.
But this resolution has been adopted in respect of 54 members.
Because not the 54 members, not they did not supply the necessary particulars for the association to find out whether they qualify to be a member of my association.
Isn't the enrollment certificate enough?
Lord, for my membership criteria, my lord, I am an associate. Kindly consider, Lord, in a club, Lord, there might be multiple criteria, Lord, to fulfill to become a member of the club. One of the criteria may be, my lord, that enrollment. The other criteria are also to be fulfilled about the, my lord, the nature of the person whom I, my lord, admit. In the bar association, my lord, if I give your lordship the rules, your lordship will find about the cessation of membership. There is a particular clause, clause 7.
All right, but then as long it is the association of the advocates, that means the first thing is that the person has to be registered as an advocate with the bar council. The moment the bar council registers, it means that the educational qualifications have been taken into consideration and then only the certificate is granted, otherwise not.
There's a presumption.
But then the bar council does not look into the criminal antecedents or anything. Possibly not. I have taken enrollment long back. I have forgotten whether this is to be disclosed or not.
Council enrollment.
Who are you, sir?
Ma'am, I'm representing your ladyship. I'm representing one of the petitioners in this case.
One of the petitioners, only one petitioner is here.
I'm supporting the petitioner.
You may support from behind. Don't open your mouth. A senior counsel is there in front of you and you are opening your mouth from behind. This is not the practice. Please follow the decorum of the court. Every day this is happening. Yesterday evening it happened. Today it is happening. Please maintain the decorum of the court. So, is there any requirement of disclosing criminal antecedents in the bar council application form?
Yes.
My lord.
Yes.
Maybe
maybe
it is
My lord, it is, my lord, it is necessary to fill up the form saying that whether any criminal proceedings is pending. But the thing is this, if he is convicted in that event only, my lord, that your lordship is aware of.
That means there is a provision for
There
disclosure.
is a, my lord, that there is.
Now, same thing.
My lord.
Wait, I'll hear you. I'll hear you. So that means there is a provision to disclose as to whether any criminal proceeding is pending against you or not.
Whether you have convicted.
Is there
Only
any
convicted.
pending criminal proceeding
Yes,
against
yes,
you?
that is there.
Pendency is also
They
there.
happened, my lord. Subsequently,
I'll hear you,
has been inflicted with this.
Yes. So, as far as the criminal proceeding is all right.
So these are not the multiple parameters we were seeking from all the members. I did not discriminate. I did not ask this from the 54 members to all the members of the bar association. They submitted. We scrutinized. We found the discrepancy in respect of the 54. We said that you cannot be a member. I never said, my lord, you cannot practice. And in the resolution also, my lord, we have marked that.
Traveling. Well, so far as the interim order is concerned.
As far as the right to practice, you cannot interfere with.
We cannot. Lord, take.
Let
your
them
lordship
practice.
Can Lord record my submission
Yes.
to that effect, because there is a fundamental right of somebody.
The whoever may be enrolled with the bar council will be entitled to practice in accordance with the Advocates Act. Do not interfere. If you do not extend your facilities, they will
That is
not
up to
avail it.
me. Lord, it is a private arrangement between the members.
Absolutely.
Yes, that's the reason I say, Lord, that the writ petition is not maintainable. I'll cite, Lord, two decisions. One division.
No decision. The very first day I raised this query, how is the writ petition
Very well.
maintainable?
Very.
So
Every time, Lord, there is a
It is
bickering
my
between the
humble
members.
submission,
Come and
my
bother your
lord.
lordship.
It is my humble submission before your lordship that if there is any discrepancy, any sort of fake, anything arising, then it should be referred to Bar Council.
It has been referred. What steps have you taken?
For verification.
What steps have you taken?
For verification.
No, what steps have you
Fresh-
taken?
Again, my lord, can you direct us to?
Why will the court direct?
Fresh
Because yours, the petitioner doesn't want verification.
No, my lord, I just come to.
Bar Council of India and Bar Council of, we have already intimated because
It-
they are
it
under
is-
the obligation to Lord inquire and find out.
It is it is your function. It is not the function of the bar association to inquire somebody's antecedents and everything. Do your work. And these
The lease details have been given.
and the right to practice of the debarred members will not be interfered
No,
in
Lord, we
any
are.
manner
Kindly
whatsoever.
take my Lord statement
is-
on that. We cannot do that.
Mr. Mukherjee, this is the best that can be done.
Well, that's right. Only my lord, let this matter my lord, kept pending because
For what reason?
only one aspect. My lord, Mr. Mukherjee, my lord, placed my lord, the two judgment, trying to place my lord, my lord, that's my lord, I have given one judgment of Kerala High Court. I think my lord,
That has been considered by the division bench here.
my lord, that Kerala High Court, my lord, they
The court is not entering into the merits. Bar association does not have any right to curtail your right to livelihood, your right to practice, your trade, profession, whatever. Do it. And against the bar association, if you are aggrieved, civil court is open. Go and file civil proceeding.
that only my lord, that in respect of my lord, what troubling me, my lord, the acts, my lord, I have handed over to your lordship, that the acts, my lord, the West Bengal Advocates Welfare Funds Acts, and he is, my lord, submitting that this is a body not, my lord, recognized by the Bar Council. This
that
body
is
is
the-
recognized under this act. So, my lord, if I intend to get, my lord, the benefit of my welfare acts, I must have to, this act says that in respect of that, and this, my lord, the bar association is amenable under this.
This
writ
is also
jurisdiction.
argued
My lord,
and
that
this
I
was
am, my
turned
lord.
down.
Well, lordship kindly see, my lord, I don't, my lord, lordship kindly.
What benefit do you want from the bar association?
No, unless I be a member, but this statute, a state statute, which says unless I be a member of the bar association, I will not get the privilege of this funds act.
What is the privilege in the fund?
Well, your lordship kindly see, these I have handed over one copy, my lord, that
Copy of?
my lord, the
Yes,
West Bengal
welfare-
Advocates Welfare Funds Act
Yes, yes,
1991.
Yes.
Now your lordship kindly see, section 22.
প্যারাগ্রাফটা বার করুন না ডিভিশন বেঞ্চে কোনটা কনসিডার করেছে প্যারাগ্রাফটা
15.6. Section 22, the provisions of this act shall
Not apply to an
to an advocate if he is not a member of a bar association. So, my lord, these funds, well, this trustee has been constituted by this under this act. The funds which has been, my lord, raised by the under the that trustee, that has to be, my lord, rendered to, my lord, the advocates who are, my lord, retired one, or even getting the some facilities by way of, my lord, in times of the, my lord, disease or something else has been done. So, my lord, I will not get the benefit of this act. My lord, this is a violation of Article 14 because, and this bar association, my lord, your lordship kindly come to this paragraph 16. Sorry, section 16. Section 16 says, my lord, no bar association shall be recognized as such by the bar council for the purpose of this act unless it is registered in the manner herein provided. My lord, they are, my lord, a recognized bar
No, we are
association.
not. We are not registered.
No,
We are
whether they,
association of person.
well, lord, whether they are not recognized by the bar council.
So the act doesn't apply.
So if that be so,
If
my lord, I
that
don't.
be so, my lord, my lord,
I don't know.
cannot
I don't
argue
know,
on
my lord,
this.
that.
That is what he's saying. The bar association is not registered.
And this
Well,
point
this
has
is
been
not
squarely
only
dealt with by the
registered,
division
whether
bench.
they are recognized by the bar council.
They are not. They have not applied for
So, my lord,
recognition.
my lord, if I negativity, my lord, negative equity, then how they send this, my lord, for before the bar council asking the verifications of these documents?
That is for the bar council to decide whether
I am on
whether no that is for the bar council to decide whether to accept their application request or not.
As because they are saying they are not a registered and they are not recognized.
This
My
is
lord,
between
much
the
obliged.
bar council and the association.
Yes, my lord, much
So-called
obliged.
association.
My lord.
But are you sure, Mr. Mukherjee, your association is not registered?
All my office bearers are here, my lord.
They
I
say-
have twice.
Well, they are holding
How
up,
can this be?
holding a
They
room
should
in the
not be.
courtroom. They are
Our bar
holding a premise
association
in the
last
court
lord, 1.5
premises
years
My
lord, ago,
It got
they got it
registered.
registered.
without registering
Not getting
themselves. They are
registered.
holding a room in the court premises, and they are, my lord, the signboards are there.
Sign what a signboard.
They are occupying a room in the courtroom without getting the registration of the bar association. I don't know how.
This is the submission that the High Court Bar Association was also not registered.
Yes, we can show him, lord. That is everybody knows.
Then
1.5 years
Not
back.
1.5, 1 year old.
only 1 year back they got the registration.
Yes, ma'am.
17 rooms in the High Court premises.
My lord,
Yes, ma'am.
I am also
And
warning.
then-
They are demanding more.
More.
For 30
But
years,
more.
I am here also, my lord, in that way.
Then,
No, my lord,
Then
I am not on.
so the Welfare Act will not be applicable to them also.
Yes, my lord. None of the members of the.
Will
Also.
get the
My lord,
benefits.
actually, Welfare Act, there is a subscription when it is contributed by the advocates, bar council contributing for their any emergency in hospital. That time if they file any bill, submitting bill on the basis of that, they are giving the money.
What about the insurance portion of the Bar Association? Has it materialized?
Nothing.
Nothing has
No, so far, our bar association, it has not.
Who will bail the
It
cat,
does.
my lord?
Steps were taken.
Yes, steps were taken.
And
No steps, no steps.
no, it was pursued to,
No steps, my lord.
it was.
Till date, nothing has been.
Till date, nothing, my lord.
Anyway, please
There
come.
was an attempt to do that as a group insurance.
Yes, group
It would-
insurance.
That is
But it
different.
has not
That
been
is
done.
different.
No, that is a private treaty that was being
না না প্রাইভেট ট্রিটি হয়নি
আচ্ছা
Realize করেনি সেটা কোনো কোম্পানি দিতে চাইছে না।
Only, my lord, the can maybe, my lord, can maybe disposed of and allowed, my lord, this can one.
Where is the can?
To the addition of party.
When did you file the can?
Well, it is with the record, my lord.
My lord, addition
I
of
have
party,
far
I
gone.
have strong objection, my lord, because why? Because different advocates, all their individual capacity, my lord.
They may be one added as
Why,
performer
my lord,
respondent there.
এই can
But
number
the same footings,
Actually,
man. As your lordship disposing,
Different
as
advocates.
your lordship disposing the dispute.
I'll dispose it.
Unless, yes, as your lordship disposing, let the
Achha.
can be allowed.
Yes, yes. The Chachol Bar Association is represented
কপি দিয়ে দেবেন একটা।
by the learned senior counsel. Stop. It has been submitted that the Bar Association is an unregistered one. Stop. Provisions of the West Bengal Advocates Welfare Fund Act, 1991 is applicable
না না কেন একটাই
Extra copy. একটা extra copy.
only to a registered association.
The other.
Stop. As the Bar Association is yet to be registered, the members of the association will not get the benefit of the said act. Stop. Paragraph. Learned senior counsel appearing for the Bar Association fairly admits that the Bar Association will not stand in the way of the right to practice of the subject advocates who have been debarred from using the facilities of the Bar Association.
The resolution টা বার করে রাখ। And
Stop.
the resolution to that effect has also been taken by us, my lord, that previously even, that they
16th of December?
Lord, এটা resolution এর date টা কবে? 12th of Lord, oh, I'm sorry.
16th of December. Page 57.
Resolution এ বলা আছে যেটা এক্ষুনি দেখ।
কোন resolution?
আচ্ছা।
Required হওয়া?
The
11th of December 2024, last 3 lines.
no, 16th December is the further resolution. Page 56. Acha. Next হচ্ছে
57.
Page 57, read.
Read 57.
এটা তো খালি নামগুলো রয়েছে।
No.
resolution is there. Resolution is there.
No. Page 56.
এই তো notice. এই তো notice.
হ্যাঁ, এই নোটিশটা দেওয়া হলো তো এই সার্কুলার এই রেজলিউশন বলে,
Yes,
সেই
yes.
রেজলিউশন।
That is there.
This is the resolution.
আচ্ছা,
11-12.
হ্যাঁ,
Unanimously decided on 11-12. Last 3 lines.
ওই নোটিশটা না ওটা না এই যে রেজলিউশনটা
সঙ্গে সঙ্গে
copy of
পরিচালনা সমিতি ইয়াহো
সঙ্গে সঙ্গে
that copy has not that copy has not
রাখলেও
available.
তাদের বার
আইনজীবীগণ আদালতে নিজ নিজ
Yes, yes.
কার্যপ্রণালী অব্যাহত রাখিলেও তাহাদের বার অ্যাসোসিয়েশনের সদস্য পদ হইতে রহিত করা হয়।
Since the bar association is an unregistered private body, comma, the writ court is not inclined to is not inclined to interfere in the matter. Stop. The writ petition is disposed of with the observation that the advocates who are registered with the Bar Council will not be restrained from practice in the practice by the Bar Association in any manner whatsoever. Stop. At application for addition, the applicants are aggrieved by the applicants claim to be similarly placed as the petitioner in the subject writ petition. Stop. The allegations are also the same. The allegations of the applicants are also the same. Stop. In view of the above, the application for addition of party stands allowed. Stop. The order passed in the writ petition shall be made applicable in respect of the applicants also. Writ petition disposed of.
Lords,
এটাকে রেখে দিন আর এগুলো কি দিয়েছে এগুলো সব ফেরত পাঠিয়ে দিন take the other papers. I am keeping only the resolution.
as your lordship.
ওইটাই যাবে
হ্যাঁ ক্যানটা অ্যালাউ করুন খালি
the applications
Allowed.
রেকর্ড করে
48. Yes. Yes. Oh, where is the petitioner? Then you should have mentioned it when the petitioner was there. Item number 48, if you want some relief, the matter is already there in the list. No, he is appearing virtually. As and when the matter will be called on, let him appear. Where is the difficulty?
My lord, there's only one thing, my lord, in the interim order that your lordship had passed on 17th, but there was, my lord, a recording by my lord that, my lord, that the the counts of, my lord, the lawyers were torn. But kindly, my lord, say that this is without, my lord, prejudice to, my lord, my client. And I dispute this.
This is not true. Are they allowed to?
But we are never, my lord, saying that they are right of practice. Even in our resolution, we said so. We said that
something on the ground and something on resolution on books. You know, there is a hell lot of difference.
Not here in this case particularly. Because, my lord, if I show your lordship, my lord, the certificates and all, your lordship.
No, the court is not concerned. If the certificates are false, the authority will take
on the
steps.
prima facie, I can show before you, my lord.
The Bar Association can see prima facie and the Bar Council cannot see.
But that is the difficulty, my lord, because they are turning a blind eye.
My lord, kindly direct us to one-line order, direct us
Not
to...
at all.
It's maintainable.
It is not your petition, it is not his petition. It is somebody else's petition. Why will the court pass order? Acha. The একটা লাইন কোথায় দেবেন আমি বলে দেবো, জাস্ট লিখে নিন যে since the writ petition is being disposed of without calling for any affidavits, comma, the allegations made in the writ petition are deemed not to have been admitted by the respondents.
I'm grateful.
This will suffice.
Lordship.
এটাকে একদম শেষে